Lordship, may I have your leave to mention 3 execution matters for withdrawal?
Lordship, leave be given to mention 4 execution commercial matter for withdrawal.
Good, madam.
Your Lordship, one execution matter to be withdrawn.
Call out the list.
Item number 1.
My lord, this is my section 14 application. My lord, I wish to withdraw this in view of the settlement arrived at. This is a settlement agreement. This may be taken on record. Settlement agreement is of 29th September 25. As per clause 1C2 appearing at page 5, my lord, I am required to withdraw this application. Internal page 5.
You have received 2 crores 51 lakhs.
Roman 2. Yes, yes. You have received. Sale has received. I am the contractor. I am defined as a contractor. Clause C, Roman 2.
Take down.
Thank you.
Learned counsel for the petitioner states that the present matter has been amicably settled between the parties in terms of the settlement agreement dated 29 September 2025. Full stop. In terms of clause 2C, Roman 2, the petitioner is filing the present application for withdrawal. Full stop. Since the matter stands settled between the parties, he does not wish to press the present petition. Full stop. A copy of the settlement agreement is taken on record. Full stop. The present petition is dismissed for non-prosecution.
I'm grateful.
Dismiss as withdrawn. Dismiss as withdrawn.
Item number 2.
Your Lordship, the matter has already been settled between the parties. I kindly request to withdraw the matter
Take down.
and the said connected application too.
Learned counsel for the petitioner seeks to withdraw the present petition. The same is dismissed as withdrawn. All interim order stands, if any, stands vacated. Any.
Item number 3.
My lord, I am being led by Mr. Shuddhashatta Banerjee. He mentioned the matter before your lordship yesterday, asking for a short passover, lordship.
I am led by Mr. Suman Datto. He is online, my lord.
Passover, first 5 matters, I don't give a passover.
Very well, lordship. I'll start
But-
then. He can take over once he is here. So, lordship, this matter was initially we filed a Section 9 application via the petitioner Shrey Equipment Finance Limited on
Yeah.
on the 2nd of July, my lord. The single judge was pleased to pass an order in the Section 9 application granting me certain protections, lordship.
Page.
I'll give the 2nd July order, lordship.
Have you annexed it? Is the order?
None of the orders will be annexed here, my lord, because this is a section.
Because this is the old Section 9, my lord. This is a subsequent fact, my lord. That's the reason. I'm sorry, my lord. I am online.
I will point out the facts, lordship.
Who will argue? You will argue or Mr. Dutt will argue?
My lord, Mr. Dutt is leading me, my lord, for the
He
respondent.
is leading you first.
Yes, my lord.
Yes, tell me.
Yes, lordship, kindly sees page 6, paragraph 12. However, if lordship is with me,
Yes.
However, in the facts and circumstances and balancing convenience and inconvenience, this court deems it fit to grant an injunction in respect of properties mentioned under Schedule 1B. So certain properties which they had mortgaged to us, securities were the order was passed to not alienate. If Lordship sees paragraph 3, respondent will not alienate, remove, transfer, or charge the nature and character of the above assets, securities. And some injunctions were also refused, Lordship. Thereafter, we moved in appeal to the division bench, whereby we sought certain
Your senior.
further protections. If my senior can take over, Lordship. I've just pointed out the first order.
If I just come back to the 15th September order, Your Lordship has seen by the 2nd July order, certain injunctions were granted in my favor.
That's what I was
Certain
saying.
were not. Now we carried that in appeal to the extent that we were not granted the injunction. I don't want to trouble Your Lordship with the 15th September order too much, except, my Lord, page 2. Please have a look at the third last paragraph. Mr. So-and-so appearing for the appellant suggests that the matter be remanded to a learned single judge for being heard out after exchange of affidavit. So the appellant has the opportunity of praying for other interim orders. Other what is important, no? To this course of action, Mr. Banerjee Learned Senior Counsel appearing for the respondent does not have any objection. Accordingly, without touching the merits of the case and leaving all points open, we resurrect the Section 9 application and request the learned single judge to decide the same after exchange of affidavit. Respondent will be at liberty, so and so. Kindly turns over, Milord. The next page, second paragraph. The interim order that is in operation shall continue till December 15, 2025 or until further orders of the learned single judge, whichever is earlier. Now that interim order is expired on the 15th of December. What I wanted to highlight was that 9 has been resuscitated now. And they have now not filed their affidavit at all. So it was ripe for me to mention, Your Lordship will kindly extend the interim order and keep it on any day for final hearing of the Section 9 for me to agitate the remaining prayers in my Section 9 application. More than 300 odd crores where there's a pledge and there's another collusive suit that I don't think, there's some observation with regard to that also. But this injunction, Milord, it is imperative that this gets extended. Otherwise, they'll go ahead and that's the only bit, Milord, and Your Lordship will kindly fix it on some day for hearing.
Yes.
My Lord, Your Lordship has seen the order of 15th of September 2025, where the appeal court, my Lord, has sent the matter back.
Yes.
Lord, that was the date, my Lord, where the arbitral tribunal was not yet constituted.
Yes.
Now, my Lord, by an order of 17th of September 2025,
Yes.
my junior will hand up a copy. The arbitral tribunal has been already constituted. And the arbitral tribunal has already entered appearance and is in season of the matter since 4th of November 2025. Those records, my Lord, are not before Your Lordship because Your Lordship is considering the old Section 9 application. These are facts which are served. Now, my Lord, my first contention is
with
that
Mr. Dotto's leave, if I may just indicate one thing. What he's saying is right. And
Then why have you filed this?
No, because of this. Milord, now this injunction is there in my 9. Your Lordship will kindly extend it and then I'll go to 17. That's what ArcelorMittal also required. Kindly extend
Mr.
it.
Banerjee, this is September, 17th September. Yes. You're well aware that the arbitral tribunal is constituted.
Yes, Milord.
You could have moved this application
but Milord,
much before. Why have you come here?
Well, I could not have done that of my own. The division bench in a matter.
Then you go there. You don't come here.
No, I can, Milord, but the division bench by this order has directed the Section 9 court to hear it. I could not have jumped that and gone straight away.
The Section 9 court could have heard it, but at the same time, when the arbitral tribunal has already been constituted, you could have moved this application over there.
But I would have,
rather than getting an interim,
this division bench judgment,
yes,
then for me to seek this injunction there in the 17. Yes. Unless I came before Your Lordship in 9, probably would have been a legal hurdle for me.
Why?
No, Milord,
because
as on the date when the division bench was passing an order, the arbitral tribunal was not constituted.
Correct. That's
but
exactly
subsequently,
because
the tribunal it has been constituted.
Just a minute. Yes, Mr. Dutt.
So subsequently, my lord, when it was constituted, we can't interpret the division bench order to say that even if the tribunal has been constituted, Section 9 court still has jurisdiction. That would probably be a my lord, improper reading of the appeal court judgment, in my respectful submission. My learned friend is well within his jurisdiction to go and pay the same price. He has entered appearance, my lord, he's on November.
Take an extension for SOC.
He's taken an extension as SOC, my lord.
So give me the dates. The first order has been passed on. The first one is
2nd July, my lord. 2nd July
July,
2025.
2nd July is the stay order.
Yes.
Interim stay
Then, my lord,
taken in
And
appeal.
15 September
15
2025.
September.
The order expired on
Tribunal constituted.
17 September 2025.
September.
And, my lord, first sitting held on 1st of November 2025.
No, comment first.
1st November. Second sitting, my lord, held on 6th of December. And, my lord, statement of claim filed after taking extension on 6th, filed on 15th of December. Statement of claim.
SOC filed on
15th of December, 1-5.
Before yesterday. Now, my lord, with regard to 17, if I may just address your lordship. If I may just address your lordship, please have a look at the division bench judgment. The division bench judgment resuscitates the 9. The 9 is pending. The injunction is given till 15th of December. Lord, while the 9
before that.
Lord, while with the 9 resuscitated,
Yes.
9 alive, probably I would not have been able to
Mr.
go and move
Banerjee, nine was alive when the arbitral tribunal was not constituted.
Right.
The order which has been passed is on the 15th. The tribunal gets constituted on the 17th. You should have moved on the 17th.
With
You
the
should have filed
tribunal
a section
constituted, my 9 will not automatically go. But I was only praying for this. Instead of going into this whole issue, till 15th I had the injunction. Your lordship will kindly extend it for another 2 weeks so I can move under 17th. Otherwise, they'll be taking advantage of their own wrong here. They don't file the affidavit. The injunction is till 15. 300 worth crores of pledges stayed.
You could have filed.
I should have. Lord,
with your
let me put it this way. I actually should have done that.
absolutely.
But they had come to me, and my reading of I'm being very candid. My reading of the division bench judgment was that because the 9 was resuscitated, I should have at least come before your lordship, said this, and then gone to 17, as how I had read ArcelorMittal. 17 also, if your lordship sees, because if your lordship looks at 17 and 9, simpliciter by constitution of the tribunal, I don't go out. Please have a look at the language of section 9.
Yes.
A party may, before or during arbitral proceedings or any time after. So even during, if I can show, no, I understand. I don't want to get into this. I'm not saying that your lordship will hear the 9 while the tribunal is in CSN. I'm only saying that because of the section 9 still alive, there is no room for them to say that injunction should not be extended. Your lordship will extend it for some time, give me some breathing space. I'll take it up in 17.
Subsection 3.
Simpliciter, it does not go away.
The subsection 3 is staring at my learned friend.
3 is what ArcelorMittal has now, Mittal to know. ArcelorMittal. That's the Supreme Court judgment has.
So my learned friend will have to show to your lordship that he has a highly exceptional case which he could not have approached the tribunal.
I will probably have to show that I have a highly exceptional case if I'm to move the 9 while the tribunal is there.
No. With respect, my lord,
They'll cite ArcelorMittal. They're relying on that.
Show me the judgment.
I'll show that. ArcelorMittal to mark. SR was 22 was that. না না এটা তো এর যেটা section 9, this is the one. I'll just bear with me for a minute, no? It'll just find that out. The second last paragraph, I think, has that whole thing. Look, I was only praying for this, that your lordship will kindly, I will go and file the 17, but kindly extends the interim order and gives me that breathing space so I can move the 17. This has been done throughout. The interim order expired on 15th. Not once am I contending that with the, and therefore the rigors of 9(3) is going to apply. I'm not requiring your lordship to do that arduous task here. Only thing is,
the other side wants me to pass an order on this.
yes, your lordship will pass the order. I'm only saying that the other side can't today say that because the tribunal has been constituted, the Section 9 court loses its authority to extend an injunction. Well, nothing has come forward from the other side to support this kind of a submission on jurisdiction of 9.
Yes.
Well, then it's otherwise saying that the Section 9 court will lose its power to extend an injunction which it had granted when the tribunal was not there. Because your lordship, the dates your lordship
The
has seen.
judgment, Mr. Banerjee. Where's the judgment?
Well, this is with regard to powers under Section 9. If I may just read it out, my lord, I have only.
Should have carried a copy.
Well, this 17 point, I really did not anticipate because this is not ripe for them. May I just put it differently? My lord, there is a Section 9 order. If they're arguing this on law, I'll just put this on law. There's a Section 9 order. That Section 9 order gets extended by the division bench by Section 37 appeal. This order of extension is done through 9.
That we have understood.
No, my lord, this was done when the tribunal was not there. Now the tribunal is constituted. So the respondents will have to now show to your lordship that the Section 9 court will lose its jurisdiction to extend an order that it had passed when the tribunal was not constituted, because now it has been constituted. I can always seek the extension and then get relegated to 17.
All right. Yes, Mr. Dhan.
So all I'm saying is extend it and send me back.
Let him on.
My lord, with respect, my lord, I beg to differ with my learned friend. The question of jurisdiction has been set out, my lord, in subsection 3 of section 9, which says, my lord, that once the tribunal has been constituted, the court shall not entertain an application under subsection 1 unless the court finds that the circumstances exist which may not render the remedy provided under 17 inefficacious.
This will not
So-
help you, Mr. Dutt. This will not help you. Once the arbitral tribunal has been constituted, the court shall not entertain an application. The application has already been entertained.
Right, my lord,
Right? So
with
we are only
respect,
looking at the extension. So the way you are reading it is not the correct way.
my lord, with
Not
respect,
when application is being filed. Application is already there. It had already been filed. It is just the extension which we are talking about.
my lord, only thing I'm trying to impress upon my lord, subject to what my lord feels, is that, my lord, that extension till 15th of December was at a point of time when the tribunal was not constituted. Now, my lord, my learned friend will have to show that between the date of constitution of the tribunal and till expiry, till he files a section 17 as and when he chooses, there are exceptional circumstances for your lordship to have the order extended. Otherwise, my lord, there is nothing before your lordship 7 except the fact that he says, I want to file a section 17, extend the protection. Now, to have that protection extended, as of now, my lord, in my respectful submission, the correct process is to go before the arbitrary tribunal and either ask for extension or a rehearing, whichever it be. The reason why my learned friend is asking an extension is because if he goes before the tribunal, he will have to satisfy the tribunal that he has a prima facie case. He is seeking the blessings of the court today to show that I already have an extended order.
It's already till the 15th. I can extend it for maybe a week for them to go before the tribunal without being impressed by any of the contentions to be decided. Just a minute, Mr. Banerjee. To be decided completely on merits by the tribunal.
That, my lord, if you not, because otherwise, my lord, they contend that it is an extension of the section 9 order.
No, that
But-
I'll clarify that.
Yes. In fact,
Yes.
my lord, my 9 can be converted to 17. This I'll move there. They can file their affidavits to this.
We can do that.
I leave it to your lordship, my lord, whichever way your lordship.
I have one request. Not 1 week. We have 3 working days left,
Uh,
practically.
Not
But
before the tribunal.
I'm sorry, my lord.
Not before the tribunal. The tribunal is there. You move it before
None of
10
us are
days.
going to be
Mr.
there. I don't know.
You know,
what
Mr.
Mr.
Banerjee,
Dutta-
I would have given you 2 weeks, but the manner in which you have slept over it from 17th till today, that doesn't really entitle you for 2 weeks.
এক সপ্তাহ কি ট্রাইব্যুনালটাকে your lordship will give me 10 days.
10 days. Take down.
From today. my lord.
Learned counsel for the petitioner. Learned counsel for the petitioner states that the tribunal has been Arbitral tribunal has been constituted on the 17th of September 2025. Full stop. He had preferred the present application under Section 9 of the Arbitration and Conciliation Act much prior to the constitution of the tribunal. Full stop. This court-wide order dated 2nd July 2025 had granted an interim order in favor of the petitioner. Full stop. The said Section 9 application was disposed of wide order dated 2nd July 2025. Full stop. The said order was taken in appeal in APO number
APOT number 217.
217 of 2025. Full stop. This court, by order dated 15th September 2025 in APOT 217 of 2025, had resurrected the Section 9 application and had requested the learned single judge to decide the same after exchange of affidavits. Full stop. In the meantime, the interim order, which was granted earlier, was extended till 15th February 2025
In December, my lord.
or until further orders, whichever is earlier. Full stop. Since the arbitral tribunal has been constituted on 17/9/2025, full stop, the learned counsel for the petitioner, Mr. Banerjee, seeks to withdraw the present application and approach the tribunal. Full
I was praying for
Just
this
a minute.
to be converted into my 7.
That's what I'm doing. Full stop. Let this application under Section 9 of the Arbitration and Conciliation Act be treated as an application under Section 17 of the Arbitration and Conciliation Act 1996 before the learned tribunal. Full stop. The interim order granted earlier by order dated 2nd July 2025 is further extended for a period of 10 days to enable the petitioner to approach the tribunal by way of an application. To enable the tribunal, full stop. Full stop. The tribunal shall decide the Section 17 application on its own merit without getting influenced by any of the observations of this court in its earlier orders. Full stop. With the above direction, the present application stands disclosed of.
Very grateful.
Only one thing, my lord. I believe the date of the extension by the Honorable Division Bench has gone down as 15th February. It will be 15 December.
15th December, sir.
Grateful.
Deeply.
My lord, I am appearing for the petitioner, my lord, in this matter. Section 9 petition, my lord, has passed an order on 3rd December, my lord, directing the respondent to maintain a minimum balance of rupees 1,98 lakh rupees in the account that my learned friend has provided. My lord, we have, my lord, inquired from, my lord, the HDFC bank, this very bank account, and my lord, this is the email, my lord, received from the HDFC bank.
Yes, Mr. Shanak.
Lord, here I cannot say anything as to this. It's correct. Whatever my learned friend is saying is absolutely correct. My only prayer is, my lord, has granted us 4 weeks to, my lord, comply and file an affidavit of compliance. My client, this is my own instruction, I'm saying, my client is endeavoring to do that. My client has not operated even a single rupee, and rather he's put in an amount of 1 lakh in compliance with my lord's order. Initially, when on the date when the order was passed, we had only 77,000 rupees in the bank account. I'm carrying the bank account statement as well, but we will put it in our affidavit, my lord. Kindly grant us time till the affidavit is there. We will file a compliance and show how we are complying.
This is not correct, my lord, with the greatest of respect. My lord,
may I just
the-
one more
very-
submission? Just one more submission. My lord, this is the only, my client is an LLP, my lord. This is the only bank account that we have. That's the specific contention that my client has communicated to me. We have one PAN number. This is the only account that we have, and we have not been operating it at all since my lord.
Deposit the
passing of
money.
order.
Just deposit the money.
We are, my lord. That we have time till 4 weeks. My lord has granted us from 3rd December. We
2
are
weeks or 4 weeks?
4 weeks, my lord. 2
No,
weeks was for affidavit in opposition.
All right.
4 weeks for compliance, my lord. We'll
All right.
kindly see right beneath the.
All right.
We are trying, my lord. My client is not in a very good financial state right
But
now.
whatever it is, he has to comply with this order.
Of course, my lord. No,
My lord,
no
with the
doubt about
greatest of respect, if I may, my lord, indicate, my lord, the order says, my lord, that is for 4 weeks to file affidavit.
in compliance.
My lord, if my lord kindly sees page 4, the 3rd paragraph. In view of the above discussion, this court is satisfied
4
that an
weeks, madam, 4 weeks.
Well, it says, accordingly, while the respondent may continue to operate its bank account in ordinary course of business, the respondent shall at
Madam,
all.
even if they have violated, file an application. File an application. You
My
can't orally mention a matter for violation of an order.
My lord, very well, my learned friends, my lord, contention.
He's being fair that he will deposit the money.
That
Very
is my
He's asking
specific
for 4
instruction.
weeks, so let it be after 4 weeks.
Very well.
Take down. Learned counsel for the respondent states that the
On instruction, my lord.
on instruction states that the order passed by this court on 3rd December 2025 shall be complied, and a compliance affidavit
Yes.
shall be filed to this effect.
Obliged.
List the matter, whatever the date we have already given it.
Yes,
Yes, my
in
lord.
January.
Yeah.
My lord, we'll also file.
Just after 8 weeks, my lord has.
Obliged.
Grateful.
And this is not a matter to be mentioned, madam.
My lord, the thing is, my lord,
To move an application.
my lord, kindly, and this is the account.
Application is the right way, not to be mentioned like
I
this.
appreciate that. I bow.
They have not violated or violated whatever it is, application. You can't mention a matter like this. We trust you, we keep the matters like this, but don't do this.
Very well, my lord. I shall, my lord, keep in this. Obliged, my lord. Grateful.
The matter
Yes.
is appearing at my matter.
Yes, sir.
But my prayer before your lordship was that since the award debtor for whom I am appearing has paid the entire awarded sum, cost and interest for rupees 42,05,777, which amount my learned friend suggested at the time of disposal of 36 application, my lord, I have paid the entire amount. I have paid the entire amount by check, my lord, on 12th of December.
My lord,
Their advocate on record has received it on 12th of December.
may I just try and narrow it down, my lord? During the 36 days that your lordship had directed this, they have given a check. I have spoken to my client. He is agreeable, my lord. Only I was suggesting if this could be withdrawn or, my lord, it could be disposed of Tuesday, my lord, because we are putting in the check today, my lord. So, my lord, only for that
At the
purpose.
request of the parties, let this matter be listed on Tuesday. Then let's keep it in first week.
If in the event, my lord, may I
First week of
suggest-
January.
in the event the check is dishonored, liberty is given to my learned friend's client to mention this matter.
It's okay.
Dispose of matter.
We'll have it in first week of January, right after the reopening.
Very well, ma'am.
All right.
Kindly keep it
It
on
is understood, my lord. We
keep
have
it
understood only for
at
that
the
purpose, my lord.
6th.
Stay. I will keep it on the 6th.
আমি থাকবো না তোমার করে দিও
Keep it on the 6th.
very good, my lord.
Has to be mentioned.
To be mentioned. Keep it on the 6th to be mentioned. At the request of the parties, let this matter be listed on the 6th
Very good.
in the category of to be mentioned.
Cash হবে না ভাবছো?
ये dispose of नहीं है।
না আমি কেন ভাববো?
हाँ, वो dispose of।
আমি the instruction
हाँ, they'll withdraw that. So you have filed the other OMP number. What do you call that?
they have filed.
34 application is.
So let
pending
that
with
be
the-
listed.
both-
Let
both-
that be
both-
listed.
Let them accept, my lord, the amount.
उसका
that
না,
is
না, 6 তারিখ চলে আসুক দুটো।
Very well.
I'll get that matter
Yes, my lord,
listed.
let both of them be
Give me the number, please.
My lord, that is APCOM number 894 of 2025. My lord, that matter is appearing in monthly list as item number 91.
Let that be listed.
Very
ये
good,
लिख देना. At the request of the parties, let APCOM number so and so be listed on the 6th in the category of to be mentioned.
Very good.
Because I have to withdraw that application. my lord.
Yes, yes, obviously. Since it stands settled, you will withdraw that application. 6th, we'll finish it off.
91.
Sir, আজকেরটা 892 এর অন্যটা 842
842
হ্যাঁ 842 আজকে
My application for restoration, my lord, of a section 9 application.
My lord, I am appearing for respondent. My lord, kindly place this matter for not this week, my lord. Senior is in medical emergency.
It's only restoration and, my lord,
Medical
it is between
emergency.
the court and the petitioner, my lord.
Senior is not well, my lord. Kindly not.
Yeah, I'll restore it. I'll keep the section 9 on some other day. GA1, take down. This is an application seeking restoration.
At page 7, my lord.
Restoration of the present petition, comma, which was dismissed for default by order dated 22nd of September 2025. Full stop. For the reasons stated in the application, comma, the same is allowed, comma, the present petition is restored to its original position. Full stop. Consequently, comma, the present petition stands allowed. Full stop. List on. Give it after January, then we'll have it.
When will you lodge?
Section
Can be in the second week of January, my lord, reopening or
14th of January.
14th.
List on 14th.
Keep it.
Great.
ये वहाँ जहाँ petition लिखा ना, consequently the present application is allowed. Application.
I appear for the petitioner, my lord. My lord, this is an application for extension of the mandate of the arbitrator, my lord.
Yes.
My lord, the arguments are complete, my lord, by both sides, my lord. The award is reserved, my lord. If your lordship takes page 38, my lord, of the application.
When was the arbitrator appointed?
My lord, the arbitrator was appointed on the 8th of December 2022, my lord. It entered reference, my lord, on the 2nd of January 2023, my lord. There has been subsequent extension, my lord. Now, my lord, the award is reserved, my lord.
Mandate was extended.
My lord, the mandate was extended, my lord, by consent of the parties, my lord, on the first occasion, and thereafter, my lord.
Which orders?
My lord, by consent of the parties, my lord will find at page, my lord, 17 of the application, my lord.
And by the order of the court?
My lord, page 19, my lord, by an order dated 5th November 2024, my lord, and thereafter, my lord, at page 34.
Page 34, order dated?
Page 34, my lord, the order dated 26 June 2025, my lord, was extended up till, my lord, 17 December 2025.
17 December 25.
My lord, the order was dated 26 June, my lord, it extended up till.
On the other side, have you?
My lord, we have served them, the affidavit of service, my lord.
All right, take down. Affidavit of service taken on record. Full stop. The petitioner has preferred the present application under section 29A of the Arbitration and Conciliation Act, seeking extension of the mandate of the arbitral tribunal for concluding the proceedings and for publication of the award. Full stop. Learned counsel for the petitioner submits that this court-wide order dated 8th, right? 8th of December. 8th December.
26 June, my lord, it had extended the mandate.
The first arbitrator was appointed 8th December.
8th December 2022.
This court-wide order dated 8th of December 2022 had appointed the sole arbitrator to adjudicate the disputes between the parties. Full stop. Thereafter, with the consent of the parties, the mandate of the arbitral tribunal was extended further for a period of 6 months. Full stop. Thereafter, by order dated 5/11/2024 and 6
June 2025.
2025, this court extended the mandate of the tribunal by 6 months each. Full stop. It is further submitted that the mandate of the arbitral tribunal has expired on 17/12/20, will be expiring on 17/12.
Today, my lord.
Today. Has expired on 17/12/2025. Full stop. None appears for the respondent despite service. The learned counsel for the petitioner states that the tribunal has already held 41 hearings and the final argument has concluded. Full stop. Upon consideration of the materials on record, this court is satisfied that no delay is attributable to the learned sole arbitrator. Full stop. Having regard to the advanced stage of the proceeding and in the interest of justice, the mandate of the learned sole arbitrator is further extended for a period of 3 months from today. Full stop. The learned sole arbitrator is requested to publish the award within the extended time period. Full stop. With the aforesaid observation, the present application is disposed of.
Grateful, my lord.
Present petition is disposed of. 29 application. क्या नाम है आप?
Your Lordship, I am appearing on behalf of the petitioner. Your Lordship, this Section 29 application was filed for seeking extension of arbitration mandate for third time, Your Lordship.
Where's the other side?
It has been served,
Where's the affidavit of service?
Affidavit of service has been filed. It's served the learned advocate who is appearing before the learned.
Serve the parties.
Serve the parties. Your Lordship.
Learned counsel for the petitioner seeks and is granted 2 weeks time to effect service upon the respondents list after vacation. Serve them.
Yes, Your Lordship. I will serve. Also,
serve the parties. Why do you only serve the lawyers?
Your Lordship, in the minutes it had been recorded that there is no objection for extension.
Yes.
I will serve. I will serve.
Service should be effected.
I will serve. I will serve. Much obligation.
Fine.
Opposing this application.
I'm appearing on behalf of the petitioner, my lord.
Sorry, my lord. On that day, my lord, I had to take it.
Yes.
I'm grateful, my lord, to you, Lordship.
My lord, my Section 9 application, primary claim is against goods sold and delivered. The petitioner company is manufacturer of PP woven sacks, my lord, and the respondent company is manufacturer and supplier of cement. My lord, in the year 29th May 2024, the respondent issued a purchase order upon us for supply of 8 lakh quantity of cement bags, which we did, my lord. Pursuant thereto, on 29th June.
What is the stage? The arbitrator has not been appointed.
My lord, we have issued the 21 notice
Section
to them.
21 notice have been given to us. Maybe day
We
before
have-
or
No, my lord.
3-4 days back we have received it.
Then
Section 9, my lord, initially they did not, my lord, they wanted security. My lord, according to us, my lord, in my respectful submission, completely disputed claim, my lord, where, my lord, we have stated that we have, my lord, paid the entire sum because, my lord, we have, my lord, paid more than 50%. Really, my lord, in short, my lord, may I just 2 minutes of your lordship. My lord, my lord, we are a cement manufacturer plant. They, my lord, filed an application, my lord, saying that, my lord, you give us security in the nature of Order 38, Rule 5, or Section 9 has been filed, where, my lord, initially no order had been passed. My lord, our contention was that, my lord, the cement bags which were given were defective. The report shows that it is defective. They say that the report is only restricted to a small amount of bags, not the entirety. We have, my lord, evidence to show that it relates to the entire amount of bag. We raised debit notes, and, my lord, those debit notes, my lord, they are, my lord, not accepting. My lord, this is, my lord, really the dispute, out of which, my lord, more than, my lord, 50% of the amount of invoice that they have raised, we have already paid them, which is as per the contractual stipulation. So, my lord, we have also shown our balance sheet. My lord, cement manufacturing plant, my lord, over my lord, 2,000 crores is my lord, my asset value. So, my lord, I am not my lord, fly by the my lord, night operator where I will my lord, dispose of my assets or my lord, siphon of funds, which is my lord, the ingredients of my lord, getting an order under for security, my lord, under Order 38 Rule 5. So, my lord, this being the position, my lord, at that juncture, my lord, the initially, my lord, the order was my lord, not granted. Directions were given for filing of affidavits. Now, my lord, after completion of affidavits is before your lordship. My lord,
There's already observation on 19th of August.
My lord.
There's already an observation on 19th of August by this court.
There is an observation, my lord. I don't stand in the way if my learned friend gives the.
You don't stand in the way
if gives the surety that the money wouldn't be leaving apart a sum of rupees.
I have.
How much is the disputed amount?
My lord, the total disputed amount is 1,45,54,000.
Out of which, my lord, 88
How
lakhs
much you have been paid?
88 lakhs have already paid.
Have already been paid, my lord.
My lord, 88 lakhs, 78,288 have already been paid to them, which is more than 50%, which is the contractual stipulation. If the cement bags are of inferior quality, if they burst, if they do not have the ash content is more, all these ingredients which are not as per the contractual stipulations, which we have given a report to that extent also. The report, my lord, they do not, my lord, really, my lord, contest the report. They say that according to the report, a minimum amount is only one page. If your lordship, if I may show to your lordship, only one page. Perhaps, my lord, this will, my lord, clear a lot of, my
But
lord,
why don't you, whatever the amount is secure them, you have a financial strength.
my lord, kindly do not, my lord, because, my lord, I'll tell your lordship why. Initially, this order was not passed because, my lord, of two reasons. One, my lord, it cannot be, security cannot be granted for the mere asking until and unless the requirements under the Code of Civil Procedure, now the principles which have been enunciated under Order 38 Rule 5 are being followed under Section 9 as well. If those constituents are not there, then just for the mere asking, security cannot be provided just because I have money and I'm not siphoning out funds. Those ingredients have to be there so that an order may be passed for security. As security, they have to make a very high case that I am really a fly-by-the-night operator. I am not there.
I'm sorry, here comes Mr. Gupta.
So, one page, if I may show it to your lordship, page 78.
Now Mr. Gupta will show all the pages.
I had.
So what is the pressing urgency?
The Section 9 powers, my lord, gives that the amount in dispute in arbitration has to be secured. Order 38 Rule 5 principles, which I could see, I could hear my learned friend submit.
While coming.
That is not the law. I could have understood him submitting this in an interlocutory court. Submissions would have.
But I'll show my lord to the.
But I'll show the judgments, my lord. Everything.
That is not the law anymore.
That is not the law in Section 9.
Yes.
And in any event,
the principles,
in any event,
are there, but
in any event, even in a
test is different now.
Even in a suit, our division bench felt that those archaic principles will not apply in the modern day and age, where commercial transactions have it's a fast moving world. So those archaic principles that I would have to show this and that, and secured creditor being unsecured creditor being converted into a secured creditor, those tests are not at all applicable in a Section 9 also, because Section 9 standard is only securing the dispute in the arbitration. There is a dispute in that in the sum of rupees 55 lakhs or let that be secured. But he is a big shot company.
Malad, I'll tell you, Lord.
I am a supplier of bags.
First, let them prove, Malad, something is due and payable. I am saying nothing is due and payable.
Yes. He's a big shot cement manufacturing. I mean, this shouldn't really
for that money. What?
But I'll tell you, Lordship. First,
that
let
is not the
let-
scope. That is not the
But
scope.
I'll tell
of
you,
the sport.
Lordship. Firstly, I'll satisfy.
But
you,
I'll
Lordship,
show,
perhaps
kindly-
the principles will be enunciated. But there is a judgment of the Honorable Supreme Court where the principles will be enunciated.
Let's hear.
But kindly permits me.
One last.
Mr. Gupta then.
Yes, surely, absolutely, Mr. Gupta will make his submission.
But kindly permits me to place a list of dates from where your lordship would find when did they raise the dispute, and it is not contemporaneous. Kindly permits me, my lord, to place the list of dates, my lord. Your Lordship is looking at the list of dates. The
Yes.
first date is 29th of May 2024 when
Yes.
the purchase order was 29th May 2024 when the purchase order was placed. Now, my lord, kindly see from May 4th entry, from May to June 2024, the goods have been supplied. After that, my lord, 27th of June, that is the second entry, my lord, they raise an issue with regard to certain bags, raising complaints with regard to certain bags. Yet on 29th of June, they give us another purchase order for 2 lakh additional quantity. May I just show your lordship these 4, because these would show, my lord, the relevance of, my lord, or the irrelevance of the defense, my lord, rather. Kindly see page 23. This is the purchase order.
Yes.
Page 23 of my application. This is the purchase order.
Yes.
My lord, your lordship would kindly take a note of, my lord, page of, my lord, the SOP, the standard operating procedure, which formed part of the purchase order. My lord, that really starts from page 32, where detailed procedure for inspection and rejection have been provided. I'll take your lordship to that. Detailed procedure at different stages have been provided. Now, my lord, will kindly have a look at page 56 onwards, your lordship. I'll take your lordship back to this procedure, my lord, when I address the fallacy in their stand, my lord. Page 56 are, my lord, the tax invoices. My lord, will kindly note the dates, my lord. These range between 31st of May 2024. This goes on, my lord, to page 75. 72, which is 29th of June 2024. In fact, 75 is also there, 73. It's not really right. Yes, the challans, this goes on till page 75. So, we deliver goods between 31st of May 2025 and 29th of June 2025. These are the dates within which the goods have been delivered. There is no issue with regard to receipt of the goods. That's not an issue. Now, will kindly have a look at page 55. I'm sorry, page 55. Kindly marks the date, this is 29th of June 2024, when they give a purchase order for 2 lakh additional quantity. We'll find at page 55.
Yes.
So, this is 29th of June. Before that, page 76, if my lord is pleased to take a look at, this is a purchase order. I'm sorry, this is an email calling upon the representatives of the petitioner to be present for a joint inspection. This is the 27th June 2024 email. So, your lordship has seen after this date, they had placed the additional order for 2 lakh quantities, which I placed from page 55. Now, my lord, the joint inspection takes place. Kindly sees the date, 11th of July 2024. Page 78 is the minutes of the meeting. In this joint inspection, there have been certain remarks. Kindly sees the bottom of that page. There's a small heading, remarks and observations. Then these observations are given that breaking strength, width-wise poor quality found and not matching our PO specification. Drop impact test not found satisfactory. Out of 6 lakh bags, 1240 damage, 958 reject, 1432 mouth open found. Then my lord will kindly turn over to page 79. when they issue a debit note. My lord, kindly sees the total number of quantity 6,31,695. Has the lordship got it, my lord?
Yes.
That is the total quantity of number of bags delivered. Damaged bags is 3,336 only. So in this joint inspection, what is found is out of the 6,31,000.
Debited 20%.
I'm sorry, my lord.
That's the debited 20% you're talking about, 3,336, right?
No, my lord. Damage quantity, my lord. The next column, 3,336.
3,336.
Yes, not 20%, my lord. 0.053%.
0.053.
Yes. So, my lord, and as per the rate of the bag, the total debit note amount, including GST, comes to, my lord, 69,130 rupees only.
Yes.
So there is issue with regard to 3,336 bags out of 6,31,000 bags. We admit these goods defective, no problem. Then Malad will kindly have a look at page Malad 96. This is my demand letter. Malad calling upon them to make payment of the outstanding amount towards unpaid price of goods sold and delivered. Now there's a virtual Zoom meeting which happens, Malad. That is at page 97, where we in our email indicated the outcome of the Zoom meeting. That is page 97.
Yes.
Now it kindly turns to 98 as well. But we were assured that by 20th September 2024, the outstanding payments would be cleared. But we had mentioned this in this email at page 98. Then, my lord, in the meantime, your lordship would not find a single joint meeting, a single email, not even disclosed with their opposition, where they raise disputes with regard to any other quantity of bag. Well, the total quantity was 10,08,000.
Yes.
Out of which 3,336 only were found to be defective. We admit, no problem, debit note raised. We are not raising any issue with regard to that. But with regard to the balance 10 lakh odd bags, no issues ever. Suddenly, when we make these two demand letters and there was a Zoom meeting, they issue an email at page 100. Suddenly, out of the blue, they say, please find attached debit note as per calculation along with test report and joint inspection report. Suddenly, a debit notes come aggregating to 55 lakhs. There is nothing in the meantime. So we deliver till June. The joint inspection happens in July. We issue demand letters in August and September. There was a Zoom meeting. Assurance given that payments would be released on 20th of September. They do not do so. We issue emails calling for the payments. On 23rd of September, they come up with only, I'm sorry, this 21st of September, they come up with only a debit note. Nothing said about quality of bags, rejection, what happened, so on and so forth. So we, on 23rd of September, by an email at page 106, dispute that.
Yes.
And say that the payment credit term was for 30 days. And in the Zoom meeting, we were assured that payments would be released. So this debit notice cannot be accepted. Similar email we issued at page 106
I'm sorry, 106 we issue. Then to that, they reply by an email dated 25th September at page 112. So here comes the first time where they seek to raise disputes. When you have, may I place it, Malud? When we have given you purchase order for supply of AdStar bags, specification of the bags required was mentioned in the purchase order. Along with the purchase order, we had shared SOP for acceptance or rejection of bags. Specification requirements were also mentioned in the SOP. On receipt of supply from your side and after QC test, you were informed that the bags have a major issue of width-wise breaking strength much below the specification, and also bags have high ash content. There were several issues with bags having mouth open. Bags were failing in drop impact test, all these leading to burstage of bags. We had called you for joint inspection, and Mr. Such and Such from your side visited our plant and joint inspection, and also the same was conclusion was drawn regarding quality. Width-wise breaking strength was as low as 415 against minimum requirement of 540 on individual basis after allowing tolerance. Also, average width-wise breaking strength was such and such and requirement was such and such. Ash content in the bag was as high as 9.12 and average was 5.16 against requirement of 4% maximum. Please refer to point 5 of SOP and also Annexure 2 for requirements relating to breaking strength. Since strength was much below standard, bags were bursting at packer flow as well as during transit to the depot, and we witnessed high burstage in the mouth when bags were consumed on your request after joint inspection. Burstage of these bags led to loss of material to us, which is very heavy as compared to the cost of only bags. Further, when your executive director referred this matter to our managing director, we got breaking strength tested again and same results were observed. You will appreciate that cost of our product is much more than the cost of the bags, and burstage of these bags have given huge loss to us. Further debit note of such and such referred by you in para 1 of SOP, which is done for burstage at packer flow. Same is mentioned in the debit note as well. As per SOC, bags supplied by you are rejected bags. However, on your insistence, we have consumed this bag, which led to heavy loss to us. To settle your account, we have calculated payment at the rate fabric cost plus transportation, where you have not given opportunity of joint inspection. Where joint inspection was done, payable has been calculated based on proportionate passing in the drop impact test. Accordingly, we have shared you debit note and the amount receivable by you has been cleared in full. So, my lord, your lordship would see that in all this period, no issue was raised. When we raise this demand notices, we issue these demand notices, they rely on that SOP and, my lord, say that the quality of the bags was bad. During transportation, we found them to be breaking, so we suffered loss. Kindly sees now the SOP, which forms part of the purchase order. If my lord is pleased to take a look at page 32. Now, my lord will kindly have a look at page 35, clause H. Is, my lord, bag inspection.
Yes.
Bag inspection. Inspection of bags shall be carried out by our plant QC department within 3 working days of receipt of consignment.
Page
35. I'm sorry, madam. Page 35, clause H. Has the lordship got it, madam? Yes. Bag inspection. Inspection of bags shall be carried out by our plant QC department within 3 working days of receipt of consignment. So, my lord, I had shown from the invoices and, my lord, the challans that, my lord, the consignments were received lastly on 29th of June.
Yes.
Then, my lord, kindly sees the detailed test result shall be shared with dispatch, purchase and account department. On monthly basis, vendor evaluation will be done by QC basis, the quality of bags supplied by them and share with purchase department. So, my lord, nothing has been followed. 3 days, no. Monthly vendor evaluation, no. Nothing is followed. Sharing of test results, no. Nothing done. Now, my lord, will kindly come to the next page, page 36. After the table, my lord will find a paragraph, all sample bags. All sample bags, also remaining cut pieces of the bags used for strength checkup after proper inspection should be kept for a minimum of 30 days. After that, these may be used. A copy of the inspection report should be forwarded to purchase, F&A and dispatch. Nothing done. Then my lord will kindly come to page 37. Kindly skips 37, kindly comes to 38 straight away at clause 5 towards the middle of the page. Your lordship would find there's a clause for breaking strength of fabric and welt strength of patch. Your lordship would recollect one of their defenses is breaking strength was not up to the mark. One of the most important aspects in the bag quality is the breaking strength. The test sample selected for breaking strength, lengthwise, widthwise, and welt strength on top of the patch shall be free from any defects on visual inspection, dimensions, ends, picks, and mass requirements. The test shall be carried out on fabric samples taken from the center portion of the sack. Then kindly turns to the next page, page 13, acceptance criteria.
Yes.
The average breaking strength in both lengthwise, widthwise, and welt strength on top of bottom of closure shall not be less than value specified in BIS. None of the individual sack value shall be more than 10% below the specified value. Then my checking procedure has been given. Then my scenarios. This is very important. My the bottom of that page, scenarios. Case 1, all bags satisfy both individual and average strength criteria. Action lot shall be accepted. So it was a bounden duty on them to check if the all bags satisfy the individual and average strength criteria, then the lot should be accepted. Then next, case 2, a few bags do not satisfy individual criteria, but the lot satisfies the average strength of criteria. Action, if less than 10% bags tested fail the individual test, then the lot is accepted, otherwise subject to joint inspection. With my lord's kind indulgence, may I pause here for a moment? The test was 0.53%.
Yes.
Then also they had asked for a joint inspection. Thereafter, nothing happened. So, my lord, in my humble understanding, subject to your lordship's kind consideration, the entire lot has to be accepted, even for a case 2 situation. Then case 3, all the sample bags satisfy the individual criteria, but lot fails in average strength criteria. Then lot shall be subjected to joint inspection. Lot rejection in case of failure in joint inspection never happened. So even if they say that this failed, this joint inspection never happened. Then case 4, bags do not satisfy individual criteria or average strength criteria. Lot shall be subjected to joint inspection, again not done. Lot rejection in case of failure in joint inspection. So they have not followed the procedure with regard to assessment of strength-wise or the width-wise breaking strength. Then, my lord, similar provision is there, my lord, with regard to ash content as well, and also elongation of breaking strength. My lord, kindly sees elongation at break of fabric at page 40 towards the middle of the page.
Page 40.
Page 40, my lord. Again, kindly sees the last paragraph of under that clause. None of the sample sacks shall have percentage elongation outside the specified range given as per BIS, or else the whole consignment shall be subject to joint inspection. Page 40, my lord, has your lordship got it? Just above clause 6. Just above clause 6, page 40, that unnumbered paragraph.
Yes.
This falls under elongation and break of fabric.
Yes.
My lord, so your lordship would find that this clause mandated that for elongation at break of fabric, then also, even if it breaks, it shall be subject to joint inspection. Ash content, once again, joint inspection. Procedure, my lord, may I place it? After ash content, there is a checking procedure at page 40, my lord.
Yes.
Your lordship would kindly find clause 6 ash content at page 40.
Yes.
There's at the bottom of that page, there's a checking procedure. Procedure for determining the ash content is given in Annex 1. Ash content is allowed as per specification sheet, beyond which ACL reserves the right to reject the consignment. Then, if the lot is found having ash content 4 to 6, even after joint inspection, it may accept the site given. So, every clause provides for joint inspection and not more lip service after my demand that there are XYZ defects. Now, my lord, kindly comes to page 41. Again, drop impact test. So, my lord, each and every stage tests have been provided. Then, my lord, will kindly turn to page 45, and this is the last clause I shall trouble your lordship with. Burst stage at packing floor. This is one of the defenses taken, that there was burst stage at packing floor. Kindly see page 45. Rejection at packing floor. Has your lordship got it? Page 45. Then one burst stage. In process burst stage, till the loading of the cement bags, cement filled bags into trucks in our factory will be to vendor account. Burstage allowance of 0.10% can be given to vendor. If burstage in a particular month is more than such and such, then the cost of the burst bags shall be recoverable from the vendors after allowing burstage allowance of 0.10% from due payments on monthly basis. If the burstage is beyond such and such person, then additional penalty. Then my lord kindly skips the 2 sentences. The sentence starting with however intimation. However, intimation of the quantity of burst bags and the value recovered there again shall be sent by the purchase department to the vendors on monthly basis. Never done. Acceptance from vendor through written mail must be taken in case vendor has certain reservation. They can be called at site for joint inspection and witness of the damaged bags. Never done. Then next paragraph, unnumbered paragraph. It is the responsibility of the dispatch in charge to record the damaged and burst bags separately, vendor-wise, on monthly basis. Same data shall be shared to quality, purchase and F&A on monthly basis. Never done. So, my lord, this lip service with flowery language, if I may use the expression, after I make the demand, after they use the bags, and kindly visualize the situation. I have delivered 10,80,000 bags. But all bags are not filled up at one go. But if they see while filling, say 100, 200 bags, that the quality is not right, they would not fill up the other bags.
Where's the?
But only one other thing, section 42 of the sale of goods comes into place. This amounts to acceptance because they have not raised any issue with regard to that. But just if it so commences to your lordship, just 2 judgments. If your lordship, with regard to section 9 and order 38, completely different. Once they argue, then I shall place, or I can. Yes. Kindly permits me to place 2022 volume 20 Supreme Court cases 178. My lord will kindly have a look at paragraph 39 onwards, which is, my lord, page 190 of the report. In fact, I should place paragraph 38 onwards. I should place. In deciding a petition under section 9 of the Arbitration Act, the court cannot ignore the basic principles of CPC. At the same time, the power of the court to grant relief is not curtailed by the rigors of every procedural provision in CPC. In exercise of powers to grant interim relief under Section 9 of the Arbitration Act, the court is not strictly bound by the provisions of the CPC. While it is true that the power under Section 9 of the Arbitration Act should not ordinarily be exercised, ignoring the basic principles of the procedural law as laid down in the CPC, the technicalities of the CPC cannot prevent the courts from securing the ends of justice. It is well settled that procedural safeguards meant to advance the cause of justice cannot be interpreted in such a manner as would defeat justice. Section 9 of the Arbitration Act provides that any party may apply to a court for an interim measure or protection inter alia, 1. to secure the amount in dispute in arbitration, or to such other interim measure of protection as may appear to the court to be just and convenient, and the court shall have the same power for making orders as it has for the purpose of and in relation to any proceeding before it. May I pause here for a moment with my lord's kind indulgence? This standard is not there in the CPC. Here, my lord, I can come and say, this is my amount in dispute, please secure that. So, my lord, the rigors of CPC is not there, the provisions are much simpler in an arbitration act. The tests are much simpler, my lord. Then, my lord, the judgments have been quoted, my lord, where these principles have been laid down. My lord, we'll kindly have a note till paragraph 45, where the Supreme Court quotes various judgments, and finally, at, my lord, paragraph 47 onwards, 47 to 49, the law is laid down. My lord, we'll find that at page 194 of the report. Section 9 of the Arbitration Act confers wide powers on the court to pass orders securing the amount in dispute in arbitration, whether before the commencement of the arbitral proceedings, during the arbitral proceedings, or any time after making the arbitral award, but before its enforcement in accordance with Section 36 of the Arbitration Act. All that the court is required to see is whether the applicant for interim measure has a good prima facie case, whether the balance of convenience is in favor of interim reliefs as prayed for being granted, and whether the applicant has approached the court with reasonable expedition. If a strong prima facie case is made out and the balance of convenience is in favor of the interim relief being granted, the court exercising power under Section 9 of the Arbitration Act should not withhold the relief on a mere technicality of absence of averments, incorporating the grounds for attachment before judgment under Order 38, Rule 5 of CPC. Proof of actual attempts to deal with, remove, or dispose of the property with a view to defeat or delay the realization of the impending arbitral award is not imperative for grant of relief under Section 9 of the Arbitration Act. A strong possibility of diminution of assets would suffice. To assess the balance of convenience, the court is required to examine and weigh consequences of refusal of interim relief to the applicant for interim relief in cases of success in the proceedings against the consequences of grant of relief to the opponent in case the proceeding should ultimately fail. But here kindly visualizes, but I have, in my humble understanding, made out a prima facie case. But with regard to the SOP not being followed.
Mr. Chaudhary, you're there?
They've got reinforcements now also.
Yes.
Similar, and the balance of convenience would warrant that this amount, which is in the dispute in arbitration, be secured. But there are two other judgments. I do not know whether I. That's enough. Wait.
May I quickly give a reply, Milord?
Yes. What is the difficulty in securing him?
Disputed money claims are not to be secured, Milord, under Section 9.
Disputed money claims are not to be secured. All right.
Milord, Lordship has seen, Milord, those two documents by which, Milord, he has accepted the fact that these were, Milord, deficient supplies in his own handwriting.
Show me.
Yes. And the handwriting. The memorandum of meeting. Milord, page 78. Milord, this is...
He has very carefully taken the quote to the entire SOP, where he says that none of the procedures which are enumerated in the SOP has been followed. In terms of the scenarios which have been laid down in the SOP, those scenarios have not been fulfilled to the extent that even, see, he had supplied around 10,80,000 bags.
Yes.
All right, out of which 0.53% was supposed to be defective or of low strength.
Yes.
Scenario 1 says that, as far as it is less than 10%, they all should go. More than 10%, then the scenario takes in. There's a
Yes, there's a
difference in
clause
there.
there.
There's
But
a
here
clause
he has
there.
accepted everything. Please have a look at page 78.
Yes.
Mr. Pranam Acharya of Sai Surfactants Private Limited, that's my learned friend's client, visited our plant on date such and such, and who are present for Amrit Cement for them.
This here shown. There's only to be
Shown. Now, my lord, kindly come down. Result observation, then drop impact test. Then out of 13 bags, 2 bags bus such and such. Then please come to remarks and observations. Breaking strength width-wise poor quality found and not matching our PO specification. Then 2, drop impact test not found satisfactory. Then out of 6 lakh bags, 1240 damaged, 958 rejected, 1432.
Wait a minute. Where are you reading, Mr.?
Number 3 under remarks and observations.
Under remarks and observations,
Yes.
6 lakh.
Out of 6 lakh bags, 1240 damaged, 958 rejected, 1432 mouth open. And below this, under that, we, size such and such, ensure that the quality of bags will be improved from our next supply. Further requesting you to kindly consume the test balance quantity. So it's a request that please consume.
All
It's
that
defective.
All that you have rejected is 958 bags. The rest of them all have been consumed.
No, my lord. 6 lakh bags, 1240 is damaged, gone. 958 rejected, gone. 1432 mouth opened, gone.
Even if
which
we add,
leaves us
Mr.
360,
Chaudhary, even if we add this, this is 3,336 bags.
Yes.
Which you say are damaged.
330 bags, yes.
3,336 bags.
36 bags.
Out of 10 lakh, 80,000.
Yes.
Which comes to 0.53%.
Yes.
Which is less than your scenario 1.
Yes, but
Scenario
even the rest, please see the endorsement at the bottom, even the rest will be improved from there. Balance
The
will
rest
be
will be improved.
Now, my lord, this is page 78. My lord, please see the report 2 pages earlier. I've given them a report. Please find, my lord, page 76, my lord, it starts. Please find the chain and deputy or technical person at our plant for joint inspection, also improve bag quality. Now, my lord, please take the next page.
Yes.
Now, if your lordship, my lord, this is very difficult to read. If your lordship, my lord, enlarges it. Oh, I'm sorry, that's not possible. My lord,
page 77.
Page 77 is the report. Now, all the my lord, different factors for testing, my lord, is done. My lord, then towards the middle of the page, your lordship will see, my lord, 3 columns which are a little wider. There, my lord, mouth open, no failure, mouth open, no failure, no failure, and my lord, all the numbers, my lord, are given. And below that are the observations. 10.42% bag length not matching with PO specifications. This is bottom right hand. Then breaking strength width wise very poor quality found. But I don't have to pay for supply which is of very poor quality. Then during the drop impact test, 2 bags mouth open. 16.67% ash found higher side. Hence, this lot is rejected. Lord, we reject it.
Even if you include
After this, my lord, is the minutes of meeting, which your lordship has read. So, my lord, they agree to everything and then say, we request you to please accept. We don't, which is evident from page 91. Now, my lord, see page 91. We gave you a purchase order, our receipt, we called you for joint inspection. Widthwise breaking strength was low. Since strength was below standard bursting, Lord, I'm not reading and wasting your lordship's time. Lord, your lordship has seen. You will appreciate that cost of our product much more than cost of bags, and burstage of these bags have given huge loss to us. Then to settle your account, we have calculated.
I think I had placed the same email from page 112 where your lordship had marked.
Very
Same
good.
email is at
Lord,
page.
please take 112. তুমি কি judgment দেখিয়েছো? কোনটা? আসছিল? ওটাই দেখিয়েছো তো?
হ্যাঁ, স্যার হাউস আর একবার দেখেন না আপনি এটা
We've raised debit note and all of this is gone. Now, my lord, so this is, my lord, at best, there's no admission from me. At best, my lord, it's a disputed issue. Now, my lord, my learned friends, shown your lordship, ArcelorMittal, please have a look at just one paragraph, which is paragraph 47.
C48 also.
47 of my lord, ArcelorMittal.
C48 also after that.
I'm sorry, my lord.
C48 also.
Oh, yes, correct. My submission is that section rigors, procedural rigors of order 38 are not required to be followed by the section 9 court. Our archaic argument based on 1952 Calcutta is not, my lord, to be done after 75 years. But that doesn't mean that order 38 will not go. My learned friend has to come with a high case, which is also 48, as your lordship said, my lord, a strong prima facie case. Number one, and you must show something that I'll, my lord, run away, or my lord, I'll, my lord, disappear, something will happen. But at least, my lord, the first thing is a strong prima facie case. On the basis of any and every, my lord, money claim, there can't be, my lord, attachment. Now, after this judgment was passed, there is a judgment of the Supreme Court in Sanghi Industries, where, my lord, in a chodao. And I am, in fact, I couldn't give them yesterday, I forgot. There is a judgment of the Delhi High Court which says follow Sanghi, and this, my lord, is not to be followed because there is a conflict. But I don't have it with me. I can just.
I don't know in which perspective Delhi High Court has passed an order like that. Supreme Court has to be followed.
Yes. No, this is the later Supreme Court. Delhi High Court, my lord, recognizes both the judgments, and my lord
says we get all kinds of judgments from Delhi.
Lord, but it says.
Yes.
Now, my lord, please see, my lord, this is decided 30th September 22. SR is decided on 14th September 22. This is the later judgment. And, my lord, please have a look at paragraph 5. And the judgment which I was referring to says, my lord, that the later conflicting view should be followed. My lord, paragraph 4 and 5. And key NHO.
Yes.
And also, my lord,
Yes.
also, my lord, Raman takes judgment, my lord, 2008, volume 2, SCC, page 302. Paragraph 4 and 5, my lord, that says two things, my lord. An unsecured money claim cannot be made a secured money claim for nothing. And power under Order 38, Rule 5 is drastic and extraordinary. Lord, your lordship has read it many times. I don't want to, my lord, carry on with this. Now, if your lordship looks at SR, there was always this debate. Order 38, Rule 5 are the principles applicable to Section 9. Apropos that, my lord, it says yes, and procedural rigors does not, my lord, have to be followed. Doesn't, my lord, dilute, my lord, SR cannot and does not dilute Order 38. My lord, if you, or my lord, the principle that an attachment is a serious order for which a high case is, my lord, minimum required. In this case, I have a rejection. I have a test report. Number one, I have a rejection.
You answer my question.
Yes.
Come to the SOP.
Yes, my lord.
This is a procedure which you're supposed to follow.
Yes, that's, my lord, 12A, my lord.
12. All right. So bag inspection is page 35.
Yes.
Then you come to page 39, the assessment procedure.
Yes, my lord.
Case 1, all bags satisfy both individual and average strength criteria. Lots
Yes.
be accepted. All right. Case 2 scenario, which is your
One
case.
is not, my lord, applicable here.
Not applicable.
2.
A
Few
few
bags
bags do not satisfy individual criteria, but
lot
do not
satisfy
satisfy
the
the average
average
strength
strength criteria.
Action. If less than 10% of the bag tested fail the individual test, then the lot is accepted.
Yes.
Here, it's less than 10%.
No, my lord, answer is this, my lord. Please see, my lord, read this, my lord, with 77.
77, I'm reading it with 77. Your total consumption is 10,80,000 bags, out of which 3,336 bags have been rejected.
Yes, that's
which,
my lord on the
which
next
falls
page.
part of your rejection, bad quality, rejected, and other things, inclusive of everything, 3,336.
No, those are, my lord, 3,000 is aggravated case. And all of them have
So
a
that's what I'm
problem.
saying. Even if we take the aggravated now, okay, fine.
Why only aggravated? I asked
move
myself.
it.
My lord, just look at, my lord, 2. My lord,
Mr.
I
Shaw,
don't
this
think
is
I have, my lord,
just for
shown your lordship 2, my lord. My lord, firstly, my lord, observation 1, 10.42% bag length not matching with our PO specification.
We are not going on the specification. We are going on the rejection. All
No,
right.
but if it
Those
doesn't,
have not been rejected.
if it doesn't,
Those have not been rejected. You have only
whole lot has been rejected.
No, not whole lot.
My lord,
That's a wrong submission.
No, my lord, it's the document.
It is only no. The document is, if you see, the rejection is only. Let us see the rejection. Where's that rejection, Mr. Gupta?
70
page.
My lord, kindly permits, my lord. Page 78 is the joint inspection.
That's what we are showing. My lord, before that, the report.
78 is the joint inspection.
No,
At
show me the
page
number.
79,
Yes.
that is an email.
This is that. Yes. Page 79. Please have.
It is their email saying this is my debit note.
This is your email.
Yes.
And this is 0.53%.
Let me explain this. The chain, my lord, must be shown. Why this is, my lord, happening? My kindness
your debit
is not my weakness.
At times,
Kindness is not my
is always a
weakness.
weakness.
Just let me put it in perspective. I now have understood your lordship's mind, my lord. Why, my lord, my lord, neck is on the slaughterhouse, my lord thing. Number one, your lordship, my lord, has been given the impression that whole lot is not rejected, part is rejected, rejection is 10%. As per the SOP, if it's less than 10%, you have to pay for the rest. How can you do this? Now, my lord, 4 things I'll show your lordship. Number one, in sequence of time. And then, my lord, I leave it, my lord, to your lordship. Page 76 is first in point of time. Read with page 77. 76.
Page 76 is your joint inspection.
Asking
Furtherance of
No, asking them, no, my lord, please find the chain and depute your technical person at our plant for joint inspection. Also, improve the quality and turnover, please.
Yes.
Report of July.
My lord, report of why? Because I enclosed the report of July and because it's in very fine print, my lord, page 77,
Yes.
page 77
Yes.
very clearly says the whole the lot is rejected.
No, that's
yes,
not. No,
last
that's
sentence.
just. I can see that. Hence, this lot is rejected.
Rejected.
Which lot is rejected? It is not mentioned. But you please see page 77 from your only page. I'll show you.
Yes.
Please have the test reports, the tape test, pass fail. Majority of them have passed. Even if you see the observations which are there, to the extent of the number of bags which are there, see, you just don't go on the observations which are at the bottom of the page. You also have to see your own chart, which shows the number of bags which have been cleared, which have not been cleared, which shows that it is less than 0.53%.
No, for
that is the
different
total
things.
number. Mr.
For
Mr.
different
Chaudhary,
things.
please see the report. Read in totality the report.
Yes. So, my lord, first is sack length.
These are your 3 invoices which talks about. These are 3 invoices. All right. The quantity of the bags, and this is only for the 2 lakh bag. See, initially it was more than 6 lakh bags. Then subsequently you have placed an order for 2 lakhs bag. This is for the 2 lakhs bag which has been subsequently. The order has been placed. This is not for the entire lot. This is only for those 2 lakh. We are talking about the entire dispute which relates to the 10 lakh 80,000 bag which are there. The entire supply is 10 lakh 80,000, and your supply even after subsequently when you have found the bags to be of a lesser inferior quality, you have placed an order. Please see the inspection report.
Yes. But my lord, I just.
Why do you do that?
My lord, I just indicate.
Now you'll say
on his
that's kindness.
promise.
No, that's your
His
kindness.
promise.
That won't.
Now, my lord, now what does, my lord, I give him 70.
And this is not for the entire lot. Please see, this is only for the 2 lakh bag which you have subsequently given them.
Now, my lord, please see 78 after this.
Yes.
78 is 11th of July 24.
Correct.
This after 2 lakh bags.
Lord,
Ordered.
yes.
In June, 2 lakh bag was ordered, reordered. This after 2 lakh.
After 2 lakh bags. Now, after this, my lord.
Yes.
Out of 6 lakhs bags.
Yes.
1240 damage. So, which leaves, my lord, 3630. It's over and above 10.
This is a small portion.
Then, yes, the handwritten, in his handwriting, Further requesting
even if we add all this, your debit note itself, I'm not saying anything. Please see page 79, your debit note. See your debit note. I'm not saying anything. Your debit note. Look at the numbers. These are your numbers.
Yes, correct.
Nobody's creating these numbers.
Correct.
These are not his numbers.
We raised 5 debit notes.
Yes.
So from
see this,
page 100.
Yes. See this total quality.
50% of the খালি আমার পেমেন্ট করার কথা আছে ক্লজেস গুলো আমি
As per the debit note.
50% খালি পেমেন্ট করার কথা I have paid 88 lakhs which is much more than 50% of the
Correct.
I'm not liable to pay anything.
The clause গুলো বার কর।
Clause গুলো দেখা
My lord,
I have shown this that they only
I have shown this.
Page 26 দুটো জিনিস দেখো inspection কোথায় হবে they have said that about the inspection.
That is
We
also
are the
shown.
only one who can do the inspection.
That is also shown. My lord, my learned friend wants your lordship to see, my lord, page 26. Your lordship has seen that.
Yes.
Just answer that question. 10%. Vishito, sure.
Debit notes have been raised, which
And Milord, I just want to, Milord, tally this. If your lordship sees, Milord, 100 onwards.
You come back tomorrow with all your tallying. Let them come back.
Milord, I'm not there tomorrow.
Oh, he'll assist.
Or Milord, Monday.
Monday.
I won't run away before vacation.
Monday.
Lordship not there.
How do you know I'm there?
If your lordship is not there Monday, Tuesday, Milord, then let it be tomorrow. My learned
Or
friend will
Friday,
do
Milord.
it.
Friday, my learned
Friday
senior is
evening.
there. Nothing बोल रहा.
No, I'm going.
Tomorrow.
I'm in Odisha.
Tomorrow.
Milord, this my learned friend says, and if he can show that, then we are home. This adds up to over 10%.
You show me. That's the only question I have. You
Let
added,
Milord,
give me a calculation.
calculation.
It's up to more than 10%. we'll see.
If this adds up to 10%, then we are, Milord, out of the rope, the noose.
You show me that.
এটা কি করে দেখাবি বল?
Heard,
Oh, your lordship has seen possibly one debit note.
So we'll
There are 5 debit notes.
That is
6
later.
lakhs.
That is
6
later.
lakhs 31,000. You're right. To that
September
extent.
debit note.
6 lakh. See, total bags is 10 lakh 80,000.
Yes.
Right. The debit note which I am showing is 6 lakhs 31,000 something number of
Yes.
bags. There are few more debit note. Show it to me
Yes.
that you're more than 10%. We'll see.
5 debit note. And the initial rejection amounts will also, Milord, be harmonized. And if it's above 10%, then my learned friend's argument fails.
Let this be listed for hearing tomorrow.
Milord, I'll try to join virtually if possible.
Virtually is fine.
Otherwise, my learned friend is
Virtually
more
you
than
can-
competent.
You can join virtually.
I think he'll do a better job.
Kindly do not embarrass me like this.
My junior is elated. that I'm not
You can
there.
join virtually. He can assist. You can
Yes,
join
yes.
virtually.
আমি ভাঙ্গি দেখিয়ে দিয়েছি and yes, grateful.
I appear for the petitioner, my lord.
If I'm appearing behalf of respondent, as per my lord, I gave earlier direction, my lord, I have furnished this. My affidavit in opposition along with my bank statement, my lord, the wakalatnama also, my lord. And my lord, we have sought the petitioner.
You got it?
Yes, yes.
Want to file
Opposition
your-
have- I'm sorry, my lord.
You want to file your reply?
No, no, my lord. It's not. Same documents they have relied, my lord, what is there in the petition. Only one thing, my lord. If, my lord, your lordship will see that the compliance, I don't know what is in the nature of. Is it in an affidavit or what? It's not signed. In what manner has it been made? And it's just the bank statements. The order was for accounts, but they have just annexed the bank statements. But be that as it may, if they do not wish to provide anything, my lord, I'll just proceed. Very short matter, my lord.
Who's talk? Kiska hai? There's no signature, madam.
No signature, nothing. What is it?
What
An
have you done?
affidavit and what?
What is this? Madam, what is this? There's no signature. Who's your senior?
Led by Mr. Sunny Nandi, my lord.
Where is he?
Due to some medical emergency had happened in his house, my lord, he has.
My lord, I don't wish to take a march on her, my lord, but your lordship has been seeing, my lord. I've been running, my lord, for like
But
what to do.
I'm not going to penalize her.
Yes, yes, my lord. I'm not saying that, but my lord,
My lord, kindly give us 1 week, maybe.
1 week is after vacation now. Their purpose will be served, my lord.
This can't be affidavit.
My sincere apology to you.
They are describing themselves as petitioners in this matter. In this, my lord, bunch, whatever it is, an affidavit or what, I don't know.
If you push her more, she'll start
I'm
shedding
not
tears.
pushing her. My lord, then let this be on record, my lord. Next day, next week,
You
if
can't have this on record. This is nothing.
I know, my lord, but what to do?
There are no signatures. This is not.
This is, I think, 5th time. Either their clients are not able to understand the order or something
Clients
is.
don't have to understand. Who's your counsel? Take down. Learned counsel for the respondent on the last occasion. on 10th of December 2025 had submitted that the affidavit had not been affirmed and had sought 1 day accommodation to do the needful, full stop. Even today, the affidavit has still not been affirmed, full stop. Proxy counsel so-and-so appears and states that the main arguing counsel has some medical emergency and is not available, full stop. This kind of practice is completely deprecated, full stop. Let this matter be listed on. We'll have it
Monday.
Friday. You'll
Yes, Friday.
Grateful to you.
Grateful, my lord. Extremely.
Just a minute. Just a minute. Yeah, from Mochuka. What are you filing? This affidavit? She's filing this affidavit.
My lord, they are filing two documents. One is an affidavit in opposition, and the other, my lord, is in the nature of compliance of the directions passed by the earlier orders, my lord. That is not signed. Affidavit in opposition is signed.
इसको strike down करो. The interim order was already there earlier, right?
Interim order was there, but my lord, subject to affidavits being filed. The order dated, my lord, 22nd of September 2025 was subject to filing of the affidavits. Now, since the bank statements are
The
disclosed,
respondent shall not encumber, alienate, change the nature and character of the.
we don't know what is
period of
happening
2
there.
months.
This particular statement is not there in the report. Neither in the affidavit in opposition nor in this report which they're calling it as a
Affidavit
report.
in opposition taken on record. Let this matter be listed. We'll have it first week of January.
But in Friday, my lord, everything is there on record. Their defense is on record.
It will be difficult.
If it's possible next week, otherwise, my lord, next month, whatever.
Let it be in January.
Very well, my lord. Grateful. Then, my lord, in the meantime, my lord, they should be directed to file a fresh report.
Whatever they want to file, let them file. Affidavit is already there. We'll
Very well,
we'll
very
decide
well.
on this.
Very well.
7th of January.
7th of January. Grateful.
Grateful to you.
Lordship, this is my Section 9 application. Lordship had passed an order on 26 November 2025. Lordship, we have served on the respondents and it has been served. Lordship, we have received something on email from the respondent. Oh, it's there. Yes, is it registered?
दिखाना क्या भेजा? पेज ठीक है. No, take down. The
Lordship, only regarding the proposal that they have stated in their opposition, alleged opposition that they have given, their proposal is 2.91 lakh. We have given them the proposal of 4.50 lakhs against a claim of 16 lakhs. Lordship, that's my submission.
The letter which he has written, he has not given any proposal.
No, Lordship, in paragraph 3, he has stated that he has given a proposal through email.
Yes, through email.
So that proposal is, Lordship, 2.90 lakhs. And again, 16 lakh, we are ready to settle the matter for 4.50 lakhs.
The respondent has written a letter to the registrar original side dated 1/12/2025 as a reply affidavit to the present section 9 application. Full stop. The same has been placed before this court by the registrar in charge original side wide, letter dated 16th December 2025. Full stop. The letter can't be treated as an affidavit in opposition. The respondent is directed to file an affidavit in opposition in proper form full stop. Is directed to file an affidavit of opposition in proper form within a period of 3 weeks. Reply, if any, within 1 week thereafter. List after 5 weeks. A copy of this order shall be communicated to the server. Copy of this order shall be communicated to the respondent for necessary action.
This is my section 9 application.
My lord, before my learned senior friend starts, my lord, I appear for the seek to appear for the respondent numbers 1, 2, and 3, my lord. My instructing advocate has not yet been able to file his the vakalatnama. So, my lord, if your lord,
I'm seeking for an interim order against my lord his bank accounts because this is the second round, my lord, of the litigation under section 9. And my lord, therefore, my lord, I have an urgent, my lord, relief which I'm seeking for. Yes,
yeah, my lord.
You are the advocate on record.
I appear for the respondent numbers 4 to 6. My learned senior friend appears for 1, 2, 3. Lord, our client has stationed out.
Yes,
If
my
Lord only has it next week. I'm not saying anything apart from that. We'll file the vakalatama so that we have that authority only next week.
Yeah, my lord,
They've
it has to
already
be on affidavit.
I take it that my lord, I can come back on Monday if your lordship wants. But from today till Monday, they should not deal with the accounts, my lord. At least, my lord, this advantage should not be
My
taken.
lordship will, my lord, record our undertaking that we'll file the vakalatnama, my lord, and we can argue.
Vakalatnama will not help him. Filing a vakalatnama, you should not deal with the
That is why I said at the outset, my
That's
lord.
the reason why he's here. Then let me state.
Before my lord passes any order, only once a
If your lordship will only see, my lord, this is the second round. Here, my lord, they had filed a section 9 application.
That is on merits. I'll make my submissions first, my lord.
Reconciliation of accounts
I'll, my lord,
not
place that. I'll, my lord, place that.
But today, my lord, if I have no right of audience, I cannot urge my case. That is the difficulty, I think.
You come back tomorrow then.
Yes.
Come back tomorrow.
Yes.
By when will you be able to
Friday?
Come back on Friday.
My lord, kindly allow us to come back on Friday.
Come back on Friday. ये ऊपर रख लेना matter ना Friday.
Since I'm seeking an interim order, may it be, my lord,
That's what I've
grateful.
Before you say that, I've already done it.
Grateful, my lord.
My lord, this is my section 9 application, my lord. I had provided a loan and they have paid few amounts, my lord. Thereafter, they have defaulted, my lord. I seek interim injunction on the bank accounts, my lord.
My lord, I am appearing for both the respondents. My lord, I believe they're in talks for settlement. If my lord may grant us some time.
For the
1 week after vacation.
1 week after vacation. My client is agreeable with that, my lord.
Learned counsel for the parties. Pray for a short adjournment since since the parties are exploring the possibility of an amicable settlement. Let this matter be listed.
My lord, if they fail, we'll press for it, my lord. Injunction. If they fail, after 1 month, and then we'll press for the injunction, my lord.
Let this matter be listed. February, I'll give a date of February.
Yes, my lord.
Feb?
No, my lord. January month.
January?
January month.
Third week of January then. 27 January.
Yes.
27 January?
27 January. Yes. Much obliged, my lord. Hello, this is my section 9 application, my lord. We had provided a loan, unsecured loan, my lord.
Chief, I'm appearing on behalf of the respondent. Yesterday, the advocate on record just got the brief. So he has
Lord,
not
they don't
yet
have-
filed the Vakalatnama yet.
Yes.
Lordship, I'm praying for the accommodation for this day and kindly fix any date after reopening so that we can file the opposition as well and we can be ready for this matter.
My lord, if I don't, and I understand against that, my lord, but till that date, interim order be passed, my lord.
What
Because
are
they
you
have,
seeking in
because
this?
there was an arbitration proceeding, my lord. They had objected to the appointment of the arbitrator, my lord. Thereafter, I have come here, my lord. So till that date, my lord, interim protection may be given.
Lordship, there is only it's a loan of about 25 lakhs and 19 lakhs are pending and there if we are just give us some time to go through the brief and study the merits of the matter as well.
My lord,
Kindly
This section 9, sir.
interim protection, my lord. They have paid also in accordance with the agreement. They had paid also, my lord. So they are not denying the agreement, my lord.
Lordship, fix any date after reopening so that we can appear in a with merits. Lordship.
Secure them till then.
Yes, my lord.
Secure them with 19 lakhs and argue on the merits.
Lordship, yesterday
Put the security of 19 lakhs, argue on the merits. We'll hear you. In the meantime, you secure them.
Lordship, fix it any.
I'm fixing it. Secure them right now. We'll hear you on merits.
To take the instructions, Lordship.
Which bank account has the money? This. You have served them. Where's the brief?
Lordship, I'm not carrying it as well. Yesterday night, the advocate on record just got
Come
the
tomorrow.
My lord, tomorrow or Friday, my lord, because tomorrow is the execution.
Friday. Deeply grateful, Lordship.
Much obliged.
Can you record?
Record
Can
this,
give
my
your
lord.
name to the advocate?
Have you asked for
Yes, my lord.
attachment of the bank account?
Yes, my lord.
Where?
Prayer F, my lord. Yes. Prayer F, my lord. Page 11, prayer F, my lord.
Only injunction, not attachment. Where's the attachment?
Attachment on injunction. Attachment on injunction.
Where's the attachment of the bank account? You have not asked for it.
Injunction from.
Madam, who drafted it? Hmm? You're not even asking for it. Let it come after vacation.
Deeply grateful, Lordship.
What's your fault?
Yes. My injunction on the bank account, yes, from withdrawing.
Come on Friday.
Lordship, can you fix it on after vacation so that we can file the opposition as well, Lordship?
I understand, my lord.
I'm praising, Lordship.
What injunction? Can
I understand, my lord.
But there's no urgency, Lordship. Kindly fix it after vacation so that we can come with the.
Look at your prayer clause. You've not even asked for it. I'm not going to injunct him from operating his bank account. I can only attach
The certain
19
amount,
lakhs.
the amount of
I'm not
90
going to
lakh.
stop him from conducting his business or whatever he's doing.
Milord, order may be passed that the amount may be, sir.
You have to ask for it.
Milord, the injunction restraining withdrawing any amounts.
Any that won't help.
Amounts.
Come back on. Come on Friday.
I'll try to satisfy.
Friday. I'll come back in 5 minutes.
No, next matter is same matter, then keeps it on Friday, my lord, because the prayer is like that. No?
You are appearing next matter.
14.
On behalf of the
14. In 14.
Item number
15.
Item 15.
15
Call
and
out
16
15.
similar matter, my lord.
Yes. You'll argue the matter.
Prayer, Lord, like 14. I don't have, today morning I have been asked to appear. Well, I have seen.
Friday.
Well, only difficulty the defendant is from Gujarat.
Wherever he is. Today these are no difficulties.
Only
No difficulties.
by filing the Vakalatama, I need some time.
That's okay.
By
You
Monday,
can...
I will try to file the Vakalatama. Give your name. That would be, I can ask them for the.
Come on Friday, we'll see.
16 also same, my lord.
Call out 16 also.
16 same, my lord. Keeps it on Friday.
Yes, you have the Vakalatnama.
No, I
No, no. Till 16, my lord, similar order may be passed, my lord.
Item 16, call 16. Who's there in 16?
16.
16, nobody is appearing, my lord.
Item 16.
Kindly give your name. 16. 16, I am for this.
You are in 16.
I am in 16. I am in 16.
15?
Item 15.
15, nobody is appearing. 16.
No, I am for the 16.
Kindly give your name.
Call 15 also.
I did not 50.
No.
Versus mobile.
Friday. Friday. 16 also Friday, 15, 16 both Friday.
Yes, ma'am.
And see if you can change.
Yes, I'll do the needful, madam.
I'll just come back.
My lord, we are invoking my lord's invoking my lord's powers, my lord, under section 9 in the post-award stage. My lord, the award is for an amount of 37 lakhs odd, and my lord, the statutory period hasn't gotten over. And the reason why, my lord, in my humble submission, my lord,
Sataduru, what is it? Which application?
my lord,
Application section 9.
section 9 application in post-award stage, my lord. The date of the award is 7 November 2025. And my lord, the reason why, my lord, we cannot wait for expiry of the statutory period will be evident from a short, just a brief list of dates, my lords. Kindly give that one. At each stage, my lord, they are avoiding the proceedings, my lords. That is a difficulty. Even kindly hand that over to my lord. Kindly see, my lord, in one page, I have taken the liberty, my lord. First, my lord will see on 31st March 22, notice under section 21 was delivered. They still did not acknowledge it, did not respond. Then on 7 December 23, my lord will find that in section 11, it was recorded by the coordinate bench, my lord, that despite several attempts to serve, none appears for the respondent. After that, we attempted to serve the order passed by this honorable court. That was also successful, but it was refused. Then, my lord, the first sitting was informed by email. They still remain unrepresented. Similarly, first, second, third sitting, service was effected, but they refused to appear. Then, my lord will see the
Ex parte award. Ex parte award.
Ex parte award, but on merits also. Kindly see, my lord, on the next page. Service was successful and delivered so far as 30th November 24 is concerned, but still they did not respond. Then, my lord, statement of claim was served. Minutes of fourth sitting also served. Award passed, it is delivered, but still they don't respond. We issued a demand notice, that is received, they don't respond. And, my lord, now the affidavit of service will show, my lord, that when we serve this petition, it is delivered, but they refused. The affidavit of service shows delivery, but refusal. Kindly hand over the affidavit of service. Kindly have, my lord, page 8 of this affidavit of service. Kindly see, my lord, 7th row from the top at page 8.
Just
Return to sender refused. So they have refused to accept, my lord. And, my lord, envelope on envelope also shows refused. Envelope will appear, my lord. The original envelope will also show, my lord. Refused. On the next page, the second page, my lord, says refused. So
page 8 refused.
Yes, page 8 and plus the envelope is also there. My lord will see the original envelope. It says refused. 12 December envelope refused. Now, my lord, in this circumstance, my lord, there is a judgment, my lord, of the division bench of this court, my lord. I just wanted to place. There are other judgments, and I'll be presumptuous to cite judgments before your lordship, but just one judgment I want to show because it is relevant to the context. Kindly have, my lord. This is Srei Equipment Finance versus Raji Naik. Kindly show this. My lord.
Which paragraph is
Paragraph 8, my lord. Para 8, my lord,
Yes.
the Honorable Division Bench has said it must not be lost sight of that an arbitral award does not become immediately executable, particularly since in many cases of the present kind, the respondents are not represented in the course of arbitral reference. An arbitrator has to ensure service of the award on the respondents, and the time permitted for the respondents to challenge the award under section 34(3) of the Act has also to be taken into consideration. Thus, the reasonable time that a court would allow, so my lord, then in the facts of that case, because that concerned movable property, my lord, this receiver, etc., was appointed and relief was granted, my lord, exercising powers under section 9. And, my lord, at the stage of section post award, my lord, there is already a prima facie case in my favor because there is an award.
Yes.
So, my lord, my humble submission, my lord, will see my petition, my lord, the reliefs that I have sought. Kindly have, my lord, page 15 of the petition. My lord, I am praying for prayer C, my lord. And I've explained in the petition why, my lord, we have couched the prayer like this. Kindly have prayer C, my lord.
Page 15.
Page 15, my lord. Only to the extent of the amount, my lord, I am seeking an injunction, my lord.
Is your PAN number right?
Yes, yes.
Generally, PAN number is how many digits?
My lord, I have mentioned it at two places. My lord may have para 40 also, my lord. It is mentioned. Page number 12, top of the page, my lord. Page number 12, top of the page.
But how many digits are generally PAN numbers? 10, right? This is 11. That's why I asked you.
Is there a mistake?
To my understanding, generally it's 10. We all have a 10-digit PAN number.
क्या करूं? इनवॉइस में लिखा है ना?
You have to check that up, Mr. Satadaru.
My lord.
Because then the order is it can't be 11.
My lord, then my lord may
I'll do
aside from the PAN number, my lord may say.
But this is what you're asking for.
So my lord,
What's the bank account number?
The bank account, my lord, we have explained at para 40 to 41 that we have not been able to ascertain, which is why we are
asking. That's why I said no PAN number.
Would your lordship then consider, my lord, passing an order without mentioning the PAN number, because the respondent is there, my lord? I have just sought instructions, my lord. Last digit will not be there. One is extra.
One is extra?
I have been instructed.
Are you sure?
Yes, yes, my lord. He has received an SMS, my lord, from the client. Only the last digit one may be ignored. It's come, my lord. The client has sent one. One won't be there, my lord. Ignore. One may be omitted, my lord.
Take ground. The petitioner has preferred the present application under Section 9 of the Arbitration and Conciliation Act 1996, seeking interim protection against the respondent for securing the awarded sum of rupees 30. This how much is it? 37?
37 lakhs 8,713, my lord.
37 lakhs 8,713 as granted by the learned sole arbitrator, wide arbitral award dated
7th November 25, my lord.
7th November
25, my lord.
2025.
Yes, my lord.
2025. Full stop. It is the case of the petitioner that pursuant to the agreement dated 1/4/2013.
11th April.
11th April 2023.
2013, my lord.
2013.
Yes, my lord.
The respondent was appointed as a consignment agent of the petitioner with effect from 1/4/2013 and for marketing and sale of the petitioner's product throughout the state of Odisha. Full stop. In terms of the said agreement, during the financial year 2012-13 and 14-15, the petitioner dispatched goods directly to stockists and dealers on the instruction of the respondent. Full stop. The said transactions were treated as stock transfers, and accordingly, the respondent issued F forms. Full stop. However, the commercial tax officer CST West Bengal treated the transaction as interstate sales and demanded F forms, C forms. C forms. Full stop. The petitioner's challenge to the said determination was unsuccessful. Full stop. Consequently, the petitioner called upon the respondent to issue C forms, comma, which the respondent failed to do, comma, resulting in the petitioner being compelled to pay an additional amount to the tax authorities. Full stop. Upon the respondent's refusal to reimburse the said amount, comma, the disputes were referred to arbitration. Full stop. Ultimately, the learned arbitrator, by award dated 7/11/2025, comma, allowed the claims of the petitioner and awarded a sum of rupees 37,08,713 in its favor. Full stop. Learned senior counsel for the petitioner, Mr. Satadaru, submits that the details of the immovable property of the respondents are not known. Full stop. He seeks an interim relief by way of attachment of the respondent's bank account linked to PAN number ABYPA4852F. 2F, which inadvertently he states has been mentioned as ABYPA48F52F1. Full stop. This court notes that the PAN number cannot be more than 10 digit and the mistake is an inadvertent mistake and inadvertent mistake. Full stop. Full stop. Since the arbitral award was passed on 7/11/2025 and the statutory period for challenging the said award has not expired, comma, the learned counsel for the petitioner apprehends that unless the respondent is restrained from operating the bank accounts linked to the aforesaid PAN, comma, the respondent may withdraw or dissipate the funds, comma, thereby frustrating the enforcement of the arbitral award. Full stop. Anything else?
Just one thing, as my duty to point out, my lord, the award, my lord, is the principal sum under the award, my lord, is 22,86,760 and 10% interest has been granted and cost has been granted, and that has been calculated, my lord, at para 27 at page 8 of the petition, and hence we have arrived at 37,08,713.
Then it has to change. The awarded amount. Which para?
My lord will see at page 70. The awarded
amount is 11,67,000.
No, 22 lakhs. Kindly see, my lord. Kindly see page 70.
Awarded sum is 22,86,000.
Yes.
760.
760, and then the tribunal has granted us 10% per annum plus
86,760 along with an interest of 10%
and cost also
10% from 24/9/2020 to 31/10/2025 along with
cost of
24/9/2020 till 31/10/2025 along with cost of rupees 2,54,000 along with cost. Full stop. The sum total being 37,000 so 37,08,730. Full stop. Upon consideration of the pleadings and the arguments advanced by the learned senior counsel for the petitioner, this court is satisfied that the petitioner has made out a prima facie case inasmuch as the arbitral tribunal award dated 7/11/2025 directs the payment of a quantified sum of rupees 37,817 in favor of the petitioner. Full stop. The balance of convenience also lies in favor of the petitioner as the relief sought is only to secure the awarded amount pending the statutory period for challenge, and no prejudice would be caused to the respondent by such protective measures. Full stop. On the contrary, if the interim protection is not granted, the petitioner would suffer irreparable loss and injury, as there exists a real apprehension of the respondent dissipating the funds, thereby rendering the arbitral award a nugatory and defeating its enforcement. Learned counsel for the respondent is directed let them file their reply.
Yes,
The respondents are directed to file their affidavit in opposition within a period of 4 weeks.
Fine.
Reply to the same, if any, within 2 weeks thereafter. List after 6 weeks. After 6 weeks?
We have checked with GST or website also, that is correct.
10
Yes, yes. Most grateful.
No, but generally PAN is 10.
Yes, yes, my lord.
Affidavit. Affidavit of service taken on record. Give it down.
So this is an application under section 9.
Yes.
Well, there's a little bit of history, Malad, so far as this matter.
Affidavits, it is coming.
Yes, yes.
Affidavits were done.
Malad, after affidavits, Malad,
I was there are only 3-4 days
it
left.
does
Your
not
Lordship
change
can
the
take it up.
complexion of the matter.
It requires some further hearing. It's a hearing matter. Well, we can come back. Well, they are enjoying an order of status
It will
quo.
take a little time.
Then we'll have it in first week of January.
Malad, only one Malad direction I need. Malad, here, Malad, initially, Malad, the co-borrowers, Malad, were respondent numbers 4, 5, and 6. Now, Malad, 4 has died. Malad, 4, according to Malad, the affidavit, has Malad died, leaving behind, amongst others heirs, one Malad, one Malad Ruby Chawla, 4, 5, and 6. Now, Malad, Ruby Chawla's address is something that we don't have. We are not being able to serve her. Malad, my learned friends will have to provide that address.
My 11 is better. Well, I'll take
And
instruction
Ruby
from-
Chawla is
6.
substitute of
Malad, 4.
No. 4, 5, 6 are substitute of the deceased.
I'm sorry, 4, 5, and 6 are
Six are
substitute
substitute
of
of the
Malad, the
deceased.
original Malad deceased respondent number 4.
learned counsel for the
And I am appearing for 1 to 5 actually.
That's right, but Malad, we have to also Malad serve on
I'll
6.
find out. We have said this.
And Malad, they are Malad brothers and sisters. They will know.
I don't know. Lord.
Malad, we had also, pursuant to directions of this Honorable Court, made out a section 911 application,
No,
but
but
they're
if he's
not.
not appearing, then I can't give a direction to him to provide that.
From 1 to 5.
Malad, only to disclose Malad the name, because otherwise, Malad, even the section 11 application, we are not being able to move.
But that was also the point your Lordship said, Malad. This is a section 9 application. So Malad, they have not got any order as of now, but they are enjoying an order of status quo in another forum.
Malad, that is what I want to tell you, Lordship. What had happened is,
They must
I
go in
gave-
for arbitration.
Malad,
Actually,
may I just tell you, Lordship, section 13.2 notice and 13.4 notice were served under the surface here. Now, Malad, the notices were defected because, Malad, at that point of time, we did not know that the original respondent number 4, against whom this petition had also had died. So, Malad, we took steps to withdraw the notice, and we have in fact withdrawn the notices. In the meantime, my learned friend challenging the notices approached Malad the tribunal, DRT, and Malad, there they said that, Malad, this is the situation, the notices are bad, etc. The tribunal, at their instance, passed an order of status quo. Now, Malad, me having withdrawn the 13.2 and 13.4 notices, Malad, that order of status quo for all practical purposes does not survive. Although I have, Malad, taken steps, Malad, urging the tribunal to, Malad, dismiss my learned friend's application or, Malad, to pursue it and withdraw it, that has not happened. So, Malad, my learned friends raised the bogey of a status quo order in that proceeding to, Malad, defeat my rights. in
therefore,
this
the
proceeding.
status quo is there. I'm not saying that there is no order.
But that status quo really is nothing. I mean,
But
that is
the- but
only,
the
see,
order-
you're challenging is 13.2, 13.4 notices. right?
Measures have been challenged.
Measures have been challenged. but
Measures have
then
been challenged.
The
he has
notices
already
have been withdrawn.
He has already been That has been withdrawn. So the proceedings have been withdrawn. So what is
It
actually?
has not been withdrawn. The essay is still there.
Well, my learned friend
That
to
is
withdraw it
That is what
because
they
other
have
notices
gone.
which have been challenged, they say have been withdrawn.
They have gone for withdrawal of the
Well,
proceeding.
the idea is very clear. They say that because there's an order of status quo there, you can't ask for any order here.
But
And
why you are not initiating the
arbitration?
I have taken out an application, but I can't move the application because I don't have the name of the sixth address of the sixth respondent. I have served notices on the sixth respondent. When 21 notice given, notices served, they've all come back saying that this is not the correct address.
No, but others are there. The 11 should have been filed.
I am only saying that my learned friend should furnish me the address.
If I am really related to them, I'll give them. If I am.
Can't pass an order to that effect.
Very remotely related, only directly brothers and sisters.
And here, the respondent number 6 is not deciding as above.
They have said in their affidavit only one line: the respondent number 6 is not residing at the above mentioned property. But they have not said where she is residing. Let my learned friend disclose the address will come back on the first week of January. Except the 7th, 7th, 8th, and 9th, I'm in difficulty. Kindly, fix any other.
At the request of the parties, let this matter be listed on the 14th of January?
Yes, madam.
Yes.
14th of January.
Very grateful.
Obliged.
And I can't pass an order since you're not representing her, but
I shall find out. I shall definitely find out.
The IPF of the petitioner. But here we had being led by Mr. Chaudhary, my lord. Our clients, they've been sitting together. My lordship had granted us time to see if settlement could be worked out. My lord, our clients have been sitting with each other respectively, and in Mr. Chaudhary's office, they've made a breakthrough. Some minor points are left, but in order to work out the settlement, some time may be required because properties have to be segregated, etc. So, if
counsel for the parties state that they are exploring the possibility of an amicable settlement. Full stop. They pray for a short adjournment. Let this matter be listed January.
Lordship, in that case, Lordship will kindly, for a limited period, extend the interim order, which is expiring on the 31st.
Interim order granted earlier is further extended for a period of 4 weeks.
Great, ma'am.
Your lordships are fixing the matter on a date.
Yes, we'll fix it. After vacation.
After the 15th.
After 15th, then interim order shall be extended for 6 weeks. Then. We have 2 weeks here this side and
2 weeks that side, Lordship.
For a period of 6 weeks.
Lordship.
6 weeks. When you want?
After the 15th, I'm praying.
My lord, as my lord pleases. My lord, Mr. Mukherjee is there, my lord. Whatever his conveniences will be.
20th of January?
As my lord. Grateful, lord.
I'm for the respondent. On the last occasion, I have taken time to deposit the 75% of the awarded amount, but we have deposited some amount. Still, it's not sufficient as per the award. But we have
MSME.
Yes, your lordship. Lordship has indicated, your lordship, the sum awarded includes, your lordship, the awarded interest also. So may I just hand over amount on the principal amount. The 75% of the principal, but I have received instruction from the department. It's a government department. That's why.
Whatever it is, you have to deposit the amount.
Well, deposit, but I'm seeking more time. It's not anything else, but I'm seeking time as per the.
Every day, the taxpayers are paying money on this.
We will deposit the amount. There is no difficulty, but only instruction from the corporate office of the ASML, it has to be deposited. But I will take it.
We should recover from the officers concerned who give this kind of instructions from their salary.
That is, we will deposit, will not deny it. But
Sir, you are not doing a favor to the court. Do you understand the purpose of the act?
Time. This is the last time. At this date. And some money we have already deposited, which is not sufficient as per the award.
May I hand over your lordship the four figures? One is the awarded one, 75%, which has been deposited and which is due. At least if it reflects in the order.
Keeping that amount, which is there, I have not keep that amount. I have not calculated.
No, out of the started account, awarded amount 96 lakh 41,000, 75%, 72 lakhs, deposit portion 25 lakhs, it's coming to 46 lakh.
46 lakhs, yes, there.
That is due.
46 lakhs or not?
46 lakh 93,434.05. 46 lakh 93,434.05 is out.
Your application is maintainable only once you deposit 75%.
Yes. That's a
Learned counsel for the petitioner states that he has still not deposited the 75% of the awarded amount at the time of challenge of the arbitral award under section 34. Full stop. He states that an amount of rupees 25 lakhs 37,376.75 has been deposited. Full stop. He seeks and is granted 2 weeks time.
After the vacation, it is after 15th January.
He states that
It is convenient.
he will be depositing the entire awarded amount, 75% of the entire awarded amount before the 15th of January. Full stop. It is observed that the interest accrues on the awarded amount on a daily basis, and that the officials who are negligent and are not proactive in following up lead to the exchequer making the payment for the interest. Full stop. Such actions are deprecated by the court, where it is expected that the officers concerned should be more vigilant in taking steps in furtherance of the law rather than dragging their feet, leading to mounting interest rates, which ultimately is borne by the taxpayers. Full stop. Let this matter be listed for further consideration on
The 15th January. It is
20th January. 20th January. Do you understand, sir, what happens? Every day the taxpayer pays because of your officers. We'll recover it from your officers.
which is the amount?
They should immediately deposit the amount. In one of the matters, 42 lakhs have gone to 24 crores. And this is a typical of MSMEs. The act and the law is there to help you, not to enrich them. It has become a
There are several procedures has to be
Sir,
maintained by the department.
you are officer of the court.
I know,
You should educate them rather than making this submission here.
I'm not.
This is award dated 7th of February 2023, Your Lordship.
I'm not sure.
Just imagine the kind of interest which they are earning.
Yes. Even then it is disputed, but I am not saying. I'm not.
Whatever it is, stop the interest part at least. Deposit the money.
That should.
Yes, Mr. Madhu.
Yes, respondent award holder. But this is an application for setting aside an award dated August 21, 2023. But there are about 22 volumes. And what I propose to do, Malad, pleadings have been exchanged. We will prepare a convenience brief for your lordship.
That'll be helpful.
Malad, I tell your lordship broadly there are two issues. May I just indicate to your lordship? The learned arbitral tribunal has held that GST is a new tax. A. The learned arbitral tribunal has further held that there are two kinds of transactions involved. One direct, that is the supplies made by the contractor, that is the award holder, which have been manufactured by them only. Number two, there are indirect transactions, which are the supplies obtained from the or goods obtained from the third parties. Number three is the service component. This is a pre-GST contract which spilled over to this GST period. So the first this matter is extremely important because rather I would say it is a matter of constitutional importance because I have gone through the award to the best of my understanding and with due deference to the learned arbitral tribunal. The constitutional provisions, namely 101st Amendment Act of 2016, the bill, the statement of object and reasons, the concept of indirect and direct taxes, all have been muddled up. So, and secondly, the award is also not only opposed to fundamental policy of India, it is perverse. I will demonstrate that. The contract entered into by and between two parties has been practically rewritten. So, we will come under that clause of associate builders, which has been followed by this Sangyong and later on by this Patel Engineering and so on and so forth. Kindly allow me, I will prepare two sets, one convenience brief and also compilation of public documents to demonstrate before your lordship that GST is essentially not a new tax, but it is an introduction of a new tax regime, which was introduced for the purpose of consolidating the existing indirect taxes. GST never involved direct taxes. The lordship knows better than us. So, my lord, kindly keep it any day after vacation. In the meantime, my lord, I prepared the brief and my lord circulate the copy to my lord, Mr. Chatterjee.
We never know better than any one of you. It's just a learning process and tax. You can't say that about
it. Tax, Mr. Chatterjee is here. Mr. Chatterjee is my leader. Mr. Chatterjee is here.
We will all be learning from Mr.
surprised.
Chatterjee.
I can hear the constitutional lawyer and the tax lawyer speaking. But unfortunately, these issues were not before the tribunal. I will demonstrate that. I will. Absolutely. I will. Pleasure to hear him on the constitutional amendment, but perhaps not in this proceeding. We shall see. The proceedings, my lord, will have.
He has been arguing constitutional amendments before me. He doesn't
So,
want the flavor. He doesn't want the flavor.
No, my lord, there's a lot to learn from Mr. Chatterjee. There's a lot to learn. We opposed each other in a lot of constitutional matters and revenue matters. This is
good for me also.
Your lordship will find this is a fine amalgam between the Arbitration Act, the Contract Act, and the Constitutional Law and the GST Act. And I will demonstrate that.
So you'll file a convenience compilation.
Yes, we will file a convenience compilation.
So far as
So then I will say a joint convenience compilation.
Yes,
sir.
I think so. I think
will be better.
The two
So that you exchange
in
between
what I will do, my lord.
tune with the Supreme Court practice, there may be a nodal council
I tell you, Lordship, what happened.
Chatterjee, let me be very clear. Even as far as Delhi High Court was concerned,
Yes,
you
yes,
will always be filing a joint convenience
Yes,
complaint.
I know that.
But a couple of weeks ago,
Parties will exchange between themselves and then
but just couple of weeks ago, I was in a different matter in Supreme Court. There is much dispute regarding this appointment of nodal council. The nodal council is taken for a ride by the by both the parties, and they said this document is relevant. They say no, that document is not relevant.
But sometimes.
But it is better we do that. We will. My learned advocate will
I
record.
expect that with both of
No,
you,
no,
this will not
we
happen.
will guide.
So,
We will
There
guide.
is no issue on that.
We will guide that.
Only, Milad, I will request my learned friend to confine to the records before the.
Absolutely nothing new. But I would be relying on the Amendment Act that I can rely. That I can rely. I will rely on my lord.
Of course.
But interestingly, there's a speech by the Prime Minister also.
to show that the public policy is being.
The Supreme Court has so far said that the speech of the finance minister is relevant. Prime Minister will be for the first.
Kindly keep it any day after vacation. In the meantime, we can
Learned
sort
senior
out these
counsel of
matters.
the parties.
This
They will be filing a
housekeeping job, leave it to us.
joint convenience compilation set within a period of 4 weeks.
Yes, my lord. Yes, my 4 weeks.
1 week after vacation.
2 weeks after vacation. ধীরাজ পারবে না, পারবে না তিনি। করে নাও তুমি।
Okay.
4 weeks.
It will take 4 weeks. With the holidays and all that.
Weeks from today, which
4
means
weeks
2
from
weeks
today.
after the.
4 weeks to from today. I agree.
Within a period of 4 weeks. Let this matter be listed on. Then shall we have it in the monthly list of February?
Yes, my lord. That's better.
Month-
Kindly fix a date in the month of February. After third. After third. Third I mean. February. তাহলে স্যার নরমাল লিস্টে চলে আসবে তাহলে সাপ্লিমেন্টারি লিস্টে আফটার থার্ড মাই লর্ড এনি ডে মাই লর্ড আফটার থার্ড এন্ড টাইম অলসো মাই লর্ড উই উইল লাইক টু ডু দিস ম্যাটার
4th of February.
ফিফথ করে দিন স্যার
Fifth,
একটা
I am not
আমার তাহলে থাকতে হবে
4th of February.
4th or 5th my lord
5th is Thursday. I generally keep all execution matters.
then 4th of February my lord but my lord if I am held up my lord then I will inform the other side beforehand my lord, that I will do.
But why are you anticipating? Then we'll keep it some other day.
my lord then just
Keep it on 10th of February then.
yes 10th of February.
And will it be your, because my
Let's not fix it.
I think it will help. No time.
Time
Very
takes a toll on.
I'll not say that.
Well, once we start my lord we'll get the time.
Yes. You know it, Mr.
I'll be
Abdullah.
very eager to hear the constitutional discourse.
And the Prime Minister's speech. All rest of the matters after. After lunch. What?
Well, we were actually jointly praying for an adjournment, Lordship, because this
All
matter is before the Supreme Court. And
Yes,
my
Your Lordship.
friend says that she's appearing for the RP.
Okay.
And my lord, this matter has been reserved for orders.
Well, by an order dated 23rd September 2025, there was a stay, Your Lordship. On last occasion, Your Lordship, order was reserved for passing the order. In the meantime, written submission is to be submitted by the parties.
Hoping, my lord, by January, my lord, there should be some conclusion whether the CIRP will continue or not.
At the request of the parties, let this matter be listed. On when do you want?
February first week. By then, my lord, if a date can be given, by then we should know if the CIRP is stayed or not.
January or February.
February first week is it?
First week, February. 4th.
Grateful.
Deeply blessed.
I'm not recording because it's already recorded in the last order.
Very, very much. Just a date is posted.
Just.
Grateful.
Yes.
My lord was hearing my objection as to the maintainability of the section 34 application. My lord, Mr. Dotto has cited, my lord, Indian farmers, which my lord was considering on the last occasion. Short question involved is whether an order or an award, whatever way, my lord, the nomenclature used is irrelevant. My lord, the order accepting my plea under section 16 is an appealable order under section 37 or an impugned award which can be challenged by before 34. This is a short question involved. I had cited before, my lord, one judgment of the division bench where section 16, it was an unreported decision. I had already cited that where a section 16 was refused, an interim award or rather challenge under section 34 was filed, that was refused, went up in appeal to the division bench. The division bench has rendered a finding, my lord, that a section 34 is not maintainable.
You have to give me those judgments.
Yes, my lord. No, division bench. My lord, we had cited first and foremost, my lord, 2022 SCC 455, which was also referred to as the arbitrator. My lord, you recall I had recorded. My lord, from in Uttarakhand Post Sainik, I want to cite a couple more paragraphs. 2020 volume 2 SCC 455. I'll come to the division bench of our court last. I'll just repeat because I've already shown, my lord, the provision. Uttarakhand, if my lord kindly takes once. Sir, Ajay. My lord, if my lord takes Uttarakhand Post Sainik, my lord, I'm only relying upon two paragraphs, 7.13 and 7.14 at page 462 of the report. 7.13 and 7.14.
Yes.
My lord, may I just place very quickly, my lord? 7.13 and 7.14. In view of the provisions of section 16, the legislative policy to restrict
7.1?
7.13 and 7.14 at page 462 of the report, my lord. Yes, my lord. 7.13 and 7.14. 462. I'll just quickly place this, my lord. In view of the provisions of section 16 and the legislative policy to restrict judicial intervention at the pre-reference stage, the issue of limitation would be required to be decided by the arbitrator. Subsection 1 of section 16 provides that the arbitral tribunal may rule on its own jurisdiction, including any objections with respect to the existence or validity of the arbitration agreement. Section 16 is an inclusive provision which would comprehend all preliminary issues touching upon the jurisdiction of the arbitral tribunal. The issue of limitation, kindly note this word, the issue of limitation is a jurisdictional issue which would be required to be decided by the arbitrator under section 16 and not by the High Court. I'm skipping over that. I'm emphasizing that section 16 relates to a jurisdictional issue which has to be decided by the arbitrator. 7.14. In the present case, the issue of limitation was raised by the respondent company to oppose the appointment of arbitrator under section 11. Limitation is a mixed question of law and fact. In ITW so-and-so, a three-judge bench of this court held that the question of limitation involves a question of jurisdiction. The findings on the issue of limitation would be a jurisdictional issue. Such a jurisdictional issue is to be determined having regard to the facts and law. Reliance is placed on so-and-so. Well, I will kindly come to placetam G. Under subsection 5 of section 16, the tribunal has the obligation to decide this plea, and if it rejects the plea, the arbitral proceedings will continue and the tribunal would make the award. Malad will kindly note these words. Under subsection 6, a party aggrieved by the arbitral award may challenge the award under section 34. In IFCO so-and-so, this court held that the issue of limitation being a jurisdictional issue, the same has to be decided by the tribunal under section 16, which is based on article 16 of the model law, competence, so-and-so. My purpose of citing this decision is only one. A question as to or rather limitation is a jurisdictional issue and goes to the root of the jurisdiction of the tribunal. This is my contention. This is what has been affirmed also by the recent judgment of the Honorable Supreme Court, which I have cited. Now, Malad will kindly take Indian Farmers once, which was cited by Mr. Dotto. I can hand over a copy. Last day I put a copy in it. Indian Farmers, which I can also hand over a copy. Indian Farmers, in my humble submission, Malad, is completely distinguishable from the facts of this case. Malad will kindly take paragraph 2. And also, Malad, there are portions of it which support my case, in fact. Malad, paragraph 2 I am placing. The appellant before us, may I just place paragraph 2, Malad? The appellant, Malad has that. The appellant before us issued a tender a tender inquiry to 19 parties, including the respondent for supply of defoamers. The respondent submitted its bid, but pursuant to a letter of intent dated so-and-so was issued to the respondent for supply of so-and-so to be used for production of 3 million metric tons of so-and-so by 11th April. Malad, not important. Malad will kindly directly come to Placetum C, right above Placetum C. Malad, the sentence starting with on 3rd March 2015, if Malad has. Placetum C, on 3/3/2015, issues were framed. On 23rd July 2015, the learned arbitrator thought it fit to take up the issue of limitation first. Inasmuch as the counsel appearing for both the parties submitted that the issue could be decided on the basis of documentary evidence alone. The issue was then decided in favor of the claimant, stating that their claims had not become time barred. A petition filed under Section 34 challenged the aforesaid award, styling it as a first partial award. On 8th October 2015, Section 34 was dismissed. Thereafter, appeal. I'm not concerning or rather taking Muller to that. The question before the Supreme Court in Indian Farmers was where the issue of limitation first of all was taken up at the final stage of hearing, and the issue was decided in favor of the claimant. Therefore, Section 16 or the jurisdictional issue was rejected by the tribunal. Therefore, the provision of appeal under Section 37 did not apply, because 37(2) provides that if a Section 16 application is allowed, if a plea is allowed, then it is amenable to appeal. Or else, what the Supreme Court here holds, since it was rejected, the plea was rejected as to limitation, it is still culminates in an award, and as it decides an issue finally, though it dismisses and rejects the plea of Section 16. On that score, my lord, the Supreme Court holds that a Section 34 is maintainable. This is not the case before my lord. My lord is hearing an application challenging an order whereby my application, and I've styled my application under Section 16. Arbitrator renders an order under Section 16 accepting my plea, holding that it does not have jurisdiction to go into this issue at all on the ground of it being expressly barred by limitation. Therefore, the remedy of the claimant petitioner before my lord is available not under Section 34 but in the manner as prescribed by the statute under 37(2)(a). This is distinguishing Indian Farmers. I want to only rely upon one further paragraph of Indian Farmers, which, my lord, in my humble understanding, my lord, will also bolster my case. If my lord kindly takes paragraph,
Yes.
my lord will kindly take paragraph 24 once. My lord, here the Supreme Court was discussing the judgment of NTPC, that is 2007 4 SCC 451, where, my lord, the Supreme Court quotes with approval a concurring decision in that particular decision. May I place paragraph 24? Interestingly, in a separate concurring judgment, P.K. Balasubramaniam J. held, may I place the quoted portion? In the larger sense, any refusal to go into the merits of a claim may be in the realm of jurisdiction. Even the dismissal of a claim as barred by limitation may, in a sense, touch on the jurisdiction of the court or tribunal. When a claim is dismissed on the ground of it being barred by limitation, it will be, in a sense, a case of the court or tribunal refusing to exercise jurisdiction to go into the merits of the claim. Kindly note these words, my lord. I am relying upon this. Now, my lord will kindly come to the next page. My lord, Section 16 is again quoted. I am not taking, my lord, through the entire quoted portion, my lord, I am relying upon, but I am only placing a portion of it. Placetum B of the next page, that's, my lord, the reported page 551. Placetum D, my lord, if my lord kindly has. The sentence starting with, may I place, my lord, from in other words, my lord, Placetum D. In other words, in the challenge to the award, the party aggrieved could raise the contention that the tribunal had no jurisdiction to pass it, or that it had exceeded its authority in passing it. This happens when the tribunal proceeds to pass an award. It is in this context that subsections of Section 16 that one has to understand the content of the expression jurisdiction and the scope of the appeal provision. In a case where the arbitral tribunal proceeds to pass an award after overruling the objection relating to jurisdiction. Kindly note this. Jurisdiction. It is clear from subsection 6 of Section 16 that the parties have to resort to Section 34 of the Act to get rid of the award, if possible. But if the tribunal declines jurisdiction or declines to pass an award and dismisses the arbitration proceeding, the party aggrieved is not without remedy. Section 37(2) deals with such a situation where the plea of absence of jurisdiction or a claim being in excess of jurisdiction is accepted by the arbitral tribunal and it refuses to go into the merits of the claim by declining jurisdiction, a direct appeal is provided for. In the context of Section 16, the specific wording of Section 37(2)(a) of the Act, it would be appropriate to hold that what is made directly appealable under Section 37(2)(a) is only the acceptance of a plea of absence of jurisdiction or of excessive exercise of jurisdiction and the refusal to proceed further either wholly or in part. Now, Malad, this is a judgment that the Supreme Court relies upon and approves. Malad, will kindly see paragraph 25. Paragraph 25, in this very judgment, this observation is approved. This judgment is determinative on the issue at hand and has our respectful concurrence. Specific approval of this finding in the very case cited by my learned senior friend, which holds that if a tribunal accepts a plea and does not go into the merits of a claim on the ground of lack of jurisdiction, limitation being an issue of jurisdiction, an award cannot be challenged under Section 34, and rather it is an order to be appealed against under Section 37(2)(a). This is my specific contention. I'm formally citing the division bench judgment, but then that's all on Indian farmers. Division bench judgment had handed over, but here, as rightly pointed out by my senior friend, I don't raise issue. Here the question was whether the tribunal had jurisdiction at all. It did not deal with a question of limitation. So perhaps this won't be so relevant. Formally, I'm citing it. It just quotes that, or rather, it recognizes that an appeal has to be made if an order under Section 16 is allowed. It just reiterates the statute. So formally, I'm citing it. I'm not placing it separately. Now, once for my own satisfaction, if kindly has section, if kindly has the Arbitration Act once, Section 16, I want to place reliance on the statute itself. Section 16, will kindly take.
Yes.
Yes. Subsection 1, the arbitral tribunal may rule on its own jurisdiction, including ruling on any objection with respect to the existence or validity of the arbitration agreement. It is an inclusive, I had shown 2020 Supreme Court, it says this is an inclusive provision which includes the issue of limitation. This limitation issue falls within the confines of 16(1). It has to. Now, will kindly see subsection 5 and 6, which perhaps my learned senior friend is relying upon on the basis of Indian farmers. The arbitral tribunal may decide on a plea referred to in subsection 2 or subsection 3, and where the arbitral tribunal takes a decision rejecting the plea, continue with the arbitral proceeding and make an arbitral award. Subsection 6, a party aggrieved by an arbitral award may make an application for setting aside such an arbitral award in accordance with Section 34. Now, perhaps this application has been filed on the basis of a reading of these two subsections. This is my humble understanding. Here, if this was an order which rejected my plea against jurisdiction of the tribunal and the arbitrator proceeded to enter into the merits of the claims, that would be the award that is contemplated under subsection 6, amenable to challenge under Section 34.
He has entered into, the claims have been dismissed.
The claims have been dismissed on the ground of limitation only, which is a jurisdictional issue. Here we'll kindly see the award once, volume 11 I was placing. I had placed the findings. The arbitrator goes on a reading of the statement of claim and decides it on a question of law, does not enter into the merits of the claims itself. The Supreme Court, will kindly have the findings once directly, 1538. 1538 are the findings on the point of limitation. And this, I will also indicate the page. This was a Section 16 application that we had taken out, which was decided. Then I'll just indicate that first. I think that would be better, will give me 1 minute. My lord will kindly, I'm sorry, my lord, 1527, my lord will come to once. 1527, paragraph 5, if my lord kindly has. 5, my lord quotes the minutes of the meeting of 11th April 2025. My lord, may I place the quoted portion? At this juncture, this tribunal is required to notice and record that immediately following the recording of the evidence, the parties intend to present arguments on the following application. An application under section 16 filed by the respondent, which was docketed for consideration at the stage of final hearing. So this was a question on section 16, which was docketed for final hearing. And this plea was eventually accepted by the tribunal. The findings, my lord, will come back to at 1538 on the point of limitation. On the point of limitation, my lord, will see the findings there. I will not address on the merits of the matter. I am on the point of maintainability. My lord will kindly see, if my lord scans through the findings, my lord, it is purely on the basis of the pleadings of the statement of claim. It does not go into the evidence at all. The arbitral tribunal in its jurisdiction, my lord, finally comes to a finding that the claims are barred by limitation. Therefore, the tribunal does not have jurisdiction to go into it. And this is directly covered by the Supreme Court judgments, my lord, both placed by my learned senior friend as well as 2022 SCC. Limitation is an issue of jurisdiction. The tribunal finally, my lord, the finding is there. My lord, 1545. 1545 is the
Reading
finding.
something on 1538. Take your time, Mr.
Yes,
Mukhopadhyay.
my lord. 1538. 1538 on the point of limitation, my lord, will see this tribunal finds the statement of claim on the following pleadings and thereafter sets out the pleadings. Sets out the pleadings on the statement of claim. Para B at 1539, the tribunal is now required to notice the summary of the final bill and the RA bill submitted by the claimant to the respondent vide so and so. And then the RA bill is set out, my lord. Thereafter, paragraph C, again, my lord will see it does appear to the learned tribunal, it's subparagraph C, my lord, learned tribunal from the summary of the outstanding stated in page 11 of the SOC, a said sum of rupees 1 crore so and so pertains to claim number 1 alone. To the mind of the tribunal as on date of submitting the summary of outstanding payment of the final RA bills, which amounts to claim number 1, there is no mention of the cost overruns which comprise claim numbers 2 and 2 to 9. Therefore, to the further mind of this tribunal, the said cost overruns are separately distinguishable from the final RA bill corresponding to claim number 1. Such subparagraph D, such separate cost overruns for the period during which the said tender work was extended up to 30th October 2013 do attract the bar of limitation imposed under section 55 of the Contract Act. The tribunal therefore finds the stand of the respondent to be apposite, both from the legal and factual perspective, applicable in the context of the present facts. In Sabarmati so and so, the period of, it was held inter alia that the period of limitation for initiating CIRP under section 9 of the IBC is to be reckoned from the date of the refund as opposed to the date of commencing of IBC, and the period prescribed is 3 years as provided under Article 137 of the Limitation Act. It was also held that the delay would commence from the date of default and delay can only be condoned by section 5. I am not on that, my lord. Subparagraph F. It is clear to the learned to this learned tribunal that since claim numbers 2 to 9 do not form part of the final RA bills pertaining to the claim number 1 and are separately distinguishable, the bar of limitation would apply, having expired 3 years from the date of completion of the project on 30th October 2013 on and by 30th October 2016. Since the limitation expired much prior to the imposition of the moratorium on the 5th February 2019, claim numbers 2 to 9 are precluded from obtaining the benefit of such moratorium. This tribunal is of the further view that clause 35 of the GCC so and so, that the contract would be alive, would have arguably applied to claim numbers 2 to 9 if and only if claim numbers 2 to 9 were part of the final bill and the RA bills. Muller, the table is referred to, comprising of the total claims 8 to 9. Muller will kindly come to 1542. Accordingly, this tribunal does not find claim numbers 2 to 9 can be described as simply consequential to claim number 1 without there being any evidence of any objective factual date in support thereto. However, the same would not apply to claim number 1, which admittedly was paid on 23rd February 2017 and was protected by limitation imposed by the moratorium which arrive prior to the expiry of 3 years, so and so. G, with regard to, kindly notes, with regard to the jurisdictional basis of the learned tribunal under section 16, this tribunal usefully relies upon paragraph 7.1.3 and 1.4 of 2022 SCC, which, my lord, I have just placed. I'm skipping over that. My lord, Indian Farmers is thereafter quoted at page 1543, and thereafter, my lord, 1545 is the finding. The tribunal consciously notes the claims, notes the facts on record, but renders a decision on the jurisdiction qua limitation. And limitation being a jurisdictional issue, the tribunal was competent under section 16(1) to give a finding on that. 1545 is thereafter the finding. In view of the aforesaid discussion, the tribunal finds it competent to rule on limitation applicable to claims 2 to 9 and holds that the claims are barred by law, not entering into the veracity or genuineness of the claims. Merits are not gone into it. It is a pure question of limitation as to jurisdiction, whether there is a bar in law from the tribunal entering into it at all. Only upon overcoming the hurdle of jurisdiction would there be any question of the merits being gone into. And merits, my lord, in my humble submission, have not been gone into. Thereafter, my lord, from subparagraph H onwards is, my lord, recalling of the claimant's witness, my lord, which is not relevant for us. So, my lord, in my humble submission, this is all, my lord, that I had to say. As to maintainability only, on the merits of the award or order, whatever, my lord, deems it fit, my lord, we'll make our submissions because the petitioner is to commence. But, my lord, on maintainability, an application under section 34 perhaps will not lie. Section 37(2)(a) provides a specific remedy, which has to be considered. And Indian Farmers, my lord, will kindly know that it is completely distinguishable from our case. Here, a plea under section 16 has been accepted. The petitioner is not without remedy. The Supreme Court recognizes that from the portion of NTPC that is quoted, my lord, specific obiter of the Supreme Court is there. They are not left remediless. I am only saying, and my lord, the appeal court is also my lord. My lord has jurisdiction to hear the appeals. They only have to file it in the proper form. My objection is nothing more. Section 34 will not lie. Section 37(2)(a) of course will. No doubt about it. Now, those are my submissions, my lord. I don't have any further to say.
But only one short thing, Miller.
See, the only thing which I see, Mr. Datta, is that as far as claim 2 to 9 is concerned, it is only being dismissed on the ground of
limitation.
So if that is the case, the distinction which is being carved out in all these judgments is basically on the jurisdiction aspect, that if the arbitrator has not gone into the merit of it, then 37(2)(a) would be the appropriate procedure. If they have gone into the merit of the matter, then probably 34 lies, because they have decided that it's an interim award which can be treated as an interim award. So it should be under 34. That's what all the judgments are saying.
But one thing, Miller, needs to be highlighted is, which I have, Miller, during my...
In your case, initially, I was thinking that they have probably gone into the merit of the matter, and I was inclined, but now you have to convince me.
Right.
That 34 is maintainable.
Point of limitation, Miller, the first issue would be an issue of limitation, whether it relates to the jurisdiction of the tribunal or it relates to the admissibility of the claims. But I have made my submissions that a point of limitation is not the jurisdiction or does not relate to the jurisdiction of the adjudicator. It is in relation to the admissibility of the claims. My learned friend has cited this 2020 judgment, Uttaranchal Purv, where, Miller, the Supreme Court says that a point of limitation is a point of jurisdiction.
Yes.
Though, Miller, I am on reply to a reply, but since Uttaranchal Purv has been referred to by a subsequent judgment of the Supreme Court, and have held that a point of limitation is or relates to the admissibility of the claims. Please have a look to this judgment. This has considered the 2020 judgment. What is it? 21(7)? This is 2021, volume 7, Supreme Court cases 313. But here, but at paragraph 33, the Supreme Court, my lord, notes Uttarakhand Purv. But I must admit, my lord, this is on, my lord, the Law Commission's my lord, recommendations. First, para 33.
Yes.
Now, Miss Millard, kindly take, Millard, para 38. Limitation is normally a mixed question of fact and law and would lie within the domain of the arbitral tribunal. There is, however, a distinction between jurisdictional and admissibility issues. An issue of jurisdiction pertains to the power and authority of the arbitrators to hear and decide a case. Jurisdictional issues include objections to the competence of the arbitrator or tribunal to hear a dispute, such as lack of consent or a dispute falling outside the scope of the arbitration agreement. Issues with respect to existence, scope, and validity of the arbitration agreement are invariably regarded as jurisdictional issues, since these issues pertain to the jurisdiction of the tribunal. Admissibility issues, however, relate to procedural requirements, such as a breach of pre-arbitration requirements. For instance, a mandatory requirement for mediation before the commencement of arbitration, or a challenge to a claim or a part of the claim being either time-barred, this is their case, or prohibited until some precondition has been fulfilled. Admissibility relates to the nature of the claim or the circumstances connected therewith. An admissibility issue is not a challenge to the jurisdiction of the arbitrator to decide the claim. But the last sentence is the clincher. The issue of limitation, in essence, goes to the maintainability or admissibility of the claim, which is to be decided by the arbitral tribunal. For instance, a challenge that a claim is time-barred or prohibited until some precondition is fulfilled is a challenge to the admissibility of that claim and not a challenge to the jurisdiction of the arbitrator to decide the claim itself. In Swissboro and all that, the Singapore Court of Appeal distinguished between jurisdiction and admissibility in paragraphs 207 and 208, which reads as, jurisdiction is commonly defined to refer to the power of the tribunal to hear a case, whereas admissibility refers to whether it is appropriate for the tribunal to hear it. Waste management, etc. To this, Zachary Douglas adds clarity to this discussion by referring to jurisdiction as a concept that deals with the existence of the adjudicative power of an arbitral tribunal, and to admissibility as a concept dealing with the exercise of that power and the suitability of the claim brought pursuant to that power for adjudication, so and so. The conceptual distinction between jurisdiction and admissibility is not merely an exercise in linguistic hygiene pursuant to a pedantic hair-splitting endeavor. This distinction has significant practical import in investment treaty arbitration because a decision of the tribunal in respect of jurisdiction is reviewable by the supervisory court at the seat of the arbitration, so and so, or before so and so, pursuant to article so and so. Jurisdiction and admissibility in global reflections on international law, commerce so and so, in such and such, para such and such, is Miller the quote. Then Miller is skipping over 42 and 43. Please take 44. The issue of limitation which concerns the admissibility of the claim must be decided by the arbitral tribunal either as a preliminary issue or at the final stage after hearing, after evidence is led by the parties. But the rest I don't require to trouble your lordships with. Therefore, the fact that, Miller, the application has been nomenclated as one under section 16 does not, my lord, convert an issue of limitation from something relating to the admissibility of a claim to the jurisdiction of the tribunal. That when, my lord, I come before your lordship and raise a point of jurisdiction, I don't, point of limitation, I don't say that the court does not have jurisdiction. I say the court has jurisdiction, but the claim is, say, for example, not alive anymore. Or the or whatever is being thrashed out is no more live. Now I have got more other issues, but which I'll address if your lordship hears the section 34, because claim numbers 2 to 9 are consequential to claim number 1. Now claim number 1, the respondent admits that it is not barred. Therefore, something which is consequential to the main claim has been directed to be or held to be, my lord, time barred. On that matter, I'll make my submission. But the basic point, the distinction is, were the parties litigating at the in an application under section 16 within the confines of section 16? My respectful answer would be no, because nobody has raised the jurisdiction of the arbitral tribunal to go into the claims that have been raised before the tribunal. Right or wrong, Millard, the learned arbitrator has held that these are barred by limitation. I say, Millard, this direction or this findings are on the admissibility of the claim. And Indian farmers, Millard, whether, Millard, and Millard, section 16, of course, Millard, just please have a look to that, Millard. If I am right, then, Millard, section 16(5), if section 16 doesn't apply over here, then of course, Millard, section 16(5) and 6 will also not apply. But be that as it may, assuming it applies, kindly take Millard, subsection 5 of 16. The arbitral tribunal shall decide on a plea referred to in subsection 2 or 3, and where the tribunal takes a decision rejecting the plea, continue with the arbitral proceeding. First, Millard, this is not a plea rejected. This is a case where the plea is accepted. Now, this subsection 5 again is confined to subsection 2 and 3. Kindly have a look to Millard, subsection 2. Subsection 2 provides the period during which you can raise an issue under section 16, and thereafter the party may not be precluded. This is one of the points. The third is, so far as subsection 3 is concerned, where the tribunal is exceeding the court scope of its authority. That is also not the case.
Yes.
But the evidences which were before the tribunal till the time this jurisdiction or the limitation issue has been taken has been considered by the tribunal.
Yes.
Therefore,
anything else?
No, from my side, but only this.
Only a reply to this judgment only, my lord. My lord, here subsection 2 and 3 of section 16, my lord, is appealable. Subsection 2 and 3. 2 relates to jurisdiction, 3 relates to exceeding of authority. Now, my lord, there are 2 decisions of the Honorable Supreme Court, one cited by both, my lord, either of us, my lord, which says that limitation is an issue of jurisdiction. This last decision, my lord, seems to depart perhaps from that view. It does not expressly overrule either of the decision because it's a coordinate bench. This is also a 2-judge bench. Indian Farmers is also a 2-judge bench, and my lord, Uttarakhand is also a 2-judge bench. In the portions that are cited, my lord, I cannot dispute the proposition that is there in the judgment, my lord, cited in Nautel, but Nautel does not distinguish from Indian Farmers or, my lord, Uttarakhand Pursaini. Number 1. Number 2, my lord, even a question as to admissibility of a claim is not an adjudication on merits perhaps, my lord. Here there is a bar of limitation, an ex facie bar of limitation, which the arbitrator arrives at on the basis of the pleadings of the claimant and the documents that are annexed to the statement of claim. My lord, I took, my lord, through the award or the order, whatever it might be. Whether it is good, bad, indifferent, that will be decided on merits, of course, either in 34 or 37. My only submission is
It troubles me all the time.
So does it to me.
I won't take,
But I appreciate that.
I won't unnecessarily take my lord's time. I'm just only
No, it's good.
No.
It's, I'm praising you, because every time, you come up with something which makes head and tail. It's not that it doesn't make any sense.
Obliged.
So the arguments are really nice and
Deeply obliged.
yes.
Well, here my only point is that two decisions of the Supreme Court which say limitation is a question of jurisdiction. Two decisions clearly on that. This says it's on admissibility. Now, admissibility, my lord, in my humble submission, this is a point that is not covered to my understanding. This will probably be the first time, my lord, is covering this. Acceptance of a plea of limitation in section 16, whether appealable or challengeable under 34. I have not been able to lay hands on a particular judgment of any court on this. Now, my lord, here the question which arises here is section 2, subsection 2 and 3. Supreme Court in the first two decisions all cover subsection 2, jurisdiction, whether the tribunal ruling upon its jurisdiction accepts a plea. 3 provides authority. My lord will kindly note the change in the language by the legislature. Kindly take subsection 3 once. My lord, this is something I'm not my lord, covered by any Supreme Court judgment on this, but my lord will kindly have a look once. Subsection 3, a plea that the arbitral tribunal is exceeding its scope of its authority. Kindly notes the change in the language used by the legislature, it has to be deliberate. So, my submission is, even if I fall under the admissibility aspect as quoted by Nortel, this would be covered under subsection 3. That is, a scope of authority of the arbitrator is being exceeded by entertaining and going into the merits of a claim that is barred by limitation. It is not as...
It is a distinction. When you're talking about being barred by limitation, then it's a different thing altogether. But being barred by limitation, which is having an effect on the claim, then it is a question of admissibility. The moment it is a question of admissibility, then 34 is maintainable.
Here, Muller, I'm trying.
Here, what had happened is that, and correct me if I'm wrong, but what had happened here is these are all arising out of the claim 1, which are the RA bills. All right. And these are the subsequent bills which you're saying was, or the arbitrator is saying that it was not part of the first claim. These have been raised subsequently. So this is time barred.
Before, these claim to 2 to 9, the arbitrator
2 to 9
raised before final RA bill, since it was raised subsequently, final RA bill.
Correct.
Therefore, it fell within limitation. Right.
Correct. Barred by limitation. That's what he's saying. Barred by limitation. In that scenario, the question is not only of limitation but also of admissibility. The moment it is a question of admissibility, then 34 triggers in. Then it is attracted by 34. Because then we are narrowing the scope of 37 completely. That is prima facie
I understand.
My take on it.
My only one-line reply to that is the question of whether it is an admissible or a question of admissibility or jurisdiction, it has to be tested in a particular forum. It has to be tested. Now, the question is, my contention, at least before Muller, is that forum has to be under section 37, because good, bad, indifferent, the arbitrator has proceeded on section 16. Let us be very frank here. This point as to whether this is an admissible claim or not is coming now with better advice perhaps from Mr. My learned senior friend. It is coming now. It was an agreed protocol before the arbitrator, as I recorded in paragraph 5 of the interim order. It was agreed by both parties that this application under section 16 would be heard at the final stage along with the main matter, but this would be heard first.
It's recorded, yeah.
It's recorded. So it is an application under section 16, good, bad, indifferent. Whether the arbitrator was right in treating it as
but then that doesn't mean that section 16 doesn't give rise to 34. Section 16 give rise to 34 too. The moment it is an interim award, or it is treated, or it has the color of an interim award, because the rights are getting adjudicated. You can't say today that the rights are not getting adjudicated. They are getting adjudicated. Your 2 to 9 is completely out.
Yes.
So there's a final decision which has been taken. The moment it's a final decision, it takes a color of an interim award. And if it takes a color of an interim award, then 34 is maintainable.
But here, my only distinction which I'm trying to draw is it is not
Anyway,
an.
I will not
Of course, my lord.
pass the order. Let me
Of course, my lord.
also
My lord will have to reserve it.
Only for recollection, my lord, at this point that it is not covered under section 16, I have placed it, my lord, on the last occasion, is paragraph 4A of my objection to section 16. On the last occasion, my lord, I placed it. Limitation is not a point under section 16, was raised before the tribunal.
Yes, you had pointed it out on the
Yes.
last occasion. You had pointed out where
Paragraph 4A.
4A.
Kindly
Thereafter, the hearing was fixed under the application of section 16.
Yeah, at the time. I mean, it was taken.
Of course.
But at page 1481.
Volume 10. And my lord, my application also, my lord, will kindly note the page only 1469. I've termed it squarely under section 16. Whether the tribunal has incorrectly decided it, that's
For your satisfaction, I'll reserve it.
we will kindly consider the judgments, my lord. Of course,
I will.
nothing.
All right, take down.
But I wish your lordship gets troubled by all the juniors over here.
Absolutely. You know, that's and you know, he always comes up very interesting propositions and arguments, which helps us to think.
Definitely.
Heard. Learned counsel for the learned senior counsel, as well as the learned counsel for the respondent on the issue of maintainability. Judgment reserved.
In the case my lord is holding it to be maintainable, we would like to file an opposition. I'm just indicating
give you
on
that
the merits. On the merits of
Only on the maintainability, I'm reserving it.
But and that understanding must be there in case the learned
that's there,
tribunal fixes a date. In the meantime, we'll pray for an adjournment.
My lord, that understanding, I've taken instructions. There's no difficulty. We won't proceed before the arbitrator during the pendency.
I'm grateful.
Deep leverage.
Item number 24.
This is that matter where the award has not been stamped, but this will take some time.
Yes.
Two points which were taken by my learned friend Mr. Chaudhary was, my lord, this is our section 34 from the part of the award, my lord, which we are aggrieved by. It's a 3 crore claim. 1 crore has been granted in our favor. We are an MSME entity, my lord.
Where is it?
2 points taken. One was, my lord, that
this item
24 and 25, my lord. One is the section 34. The other one is, my lord, the section 36, which is our execution. 2 points taken, my lord. The first being that the award is an unsigned award. The 5 arbitrators, my lord, at the end of the award, it's written SD, 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 SD.
If
not
it's
signed.
broken, he'll pay for it.
No, I think it's fine.
Yes. I'm just kidding. Yes. Tell me, where is Mr. Chaudhary?
Murder. I don't know, my lord. Well, we can
Lord,
send a word.
may I
If my
submit
learned
this?
friend continues, my lord, my learned friend can send a word across.
It's still 3, so may I submit this, my lord? Because, my lord, we went through the judgments on the point. 2 points taken by them. One, my lord, is a curable defect. They say it's unstamped. It's 150 stamp, my lord, which is a curable defect. I have, my lord, judgments on that point. It's always a curable defect. The arbitral award does not, my lord, become set at naught because of that. The other point taken by them, which is, my lord, an interesting point, that this award is not signed. Now, what we have received from the, my lord, it's an institutional arbitration. What we have received from the MSME Facilitation Council, my lord, it's a certified copy of the award through an email. You know, the law for a certified copy of the award is very different from the main award.
Let me come back and you call Mr. Chaudhary. I'll come back in 2 minutes.
My lord, may I only pray for this because I think that we can
You start with the argument, we'll see.
But before I start with my argument, my lord, if a direction is given by the court, because in the other matter, which, my lord, I'm going to place reliance on, this is what has happened. My lord, a direction was given by the court to the MSME, my lord, the council, for disclosing the original records. what happens then, because we have also inquired, my lord, the original award is there, signed by all the arbitrators. My lord, if the records are called for by the honorable court, my lord, it will become easier, and because both of us will know, my lord, what is there. And then we
order
can,
which has been passed in the other matter.
my lord, it's in JD Electrical Products Private Limited. It's a longish order. I'm going to rely on this.
May I have
Give
a
you
copy since it's an unreported decision?
Definitely. In fact, the execution from this matter is pending before your lordship. My lord, very interesting. I'll take your lordship through the order. Very similar point was raised in this matter, and I'll start with this. So today, my lord, after your lordship comes back, I'll try and take your
I'll just
lordship. Yes, definitely.
Is in code 38, but he was relying upon paragraph 16 of the order. Your lordship sees paragraph 16 of the order. Okay, the court had asked the MSME council to provide the entire cost papers of the proceedings, so that to ascertain that whether the original award has been signed or not. Because here the award has been delivered, my lord, by both the means.
The court had given a direction. The court had directed.
Yes, my lord. So that is what we are asking for, so that we can then show to the court the next line of judgments which we have, that this is the original copy, and in case of institutional arbitrations, the certified copy of the original order can be relied upon.
But this
So
is
that is
slightly
No, but then this
distinguishable
slightly distinguishable to
because
the
my lord,
extent
the
that
original certified copy was delivered by post to the party who is present before the arbitral reference. Here, my lord, what my learned friend has disclosed along with his petition for setting aside is a document which does not even contain the signature of the members of the facilitation council. I do not have any objection if my learned friend writes to the facilitation council, and if he is provided with an original signed copy of the arbitral award, he can use that copy and file a fresh petition.
That is something.
As on date, my lord, the petition before your lordship is defective because my lord, the document which he has annexed to show that there is an award perhaps, my lord, is suffers from the vices of Section 31 of the Arbitration Act. Because, my lord, whatever may be at the end of the day, a signed copy need not be original signed copy, but a signed copy should be there before the court dealing with matters relating to Section 34 of the Arbitration Act. But this is this was a distinguishing factor, because, my lord, if lordship sees, my lord, page 12 of the judgment, my lord, paragraph 12, page 12, para 21, my lordship has that, my lord, para 21, page 12.
Yes.
Yes. The background of the proceeding before this court has assumed significance. A copy of the execution application was delivered at the address of the award or debtor depicted in the cause title of the execution petition. The certified copy of the signed copy of the award was sent to the same address. So there was an effective service of the signed copy of the award. This is not the case.
I'll first place. I'm sorry, my lord, I was not here.
No.
The matter was taken up. But may I only submit this? My lord, today the point which has been taken of this award being an unsigned copy is not correct. It's a certified copy of the award. I'll, my lord, show what is the interpretation of a certified copy. A certified copy need not be signed. All the certified copies need not be signed by the honorable judge or the arbitrator. But I'm carrying Black's dictionary ka interpretation layo. Huh? On what is a copy? There are judgments which have explained, Lord, the interpretation of copy and certified copy. Certified copy is not required to be signed. And what is the import and purport, my lord, of a certified copy being served? If a certified copy is served, this judgment, my lord, I'm going to place reliance on, because, my lord, if a certified copy is served and if they know of the, my lord, award, what steps have they taken? They have not challenged it under Section 34. They have waited, and they have waited, being, my lord, a government entity. They wait to take advantage against an MSME entity who has challenged this. So, my lord, today they don't have a Section 34. They don't have an application in Section 36. In Section 36, I'm moving my Section 36. In Section 36, all they have, my lord, they don't have a chance to file an affidavit in opposition. The only option they have is to file an affidavit of assets. So there is no application. If they take up this point, they can take up a point in the 34. I'm not moving my 34 today. I'm moving my 36. With my 36, it's a submission from the bar without an application, where they say this is not maintainable. 34 is not maintainable. Because my 36 is on the part which is not affecting the 34. It's on the part, my lord, that there is an award. It's a valid award in law. I'll make these submissions and I'll show more judgments which, my lord, decide this point. But before that, my lord, I need to be sure what is exactly transpiring with the tribunal. They say, my lord, on instructions, I'm submitting this, that they have the signed copy is there. So, my lord, how they have prepared the signed copy, when they have prepared the signed copy, they should come and explain it. My lord, in this judgment also, my lord, there was a direction given to the council that you disclose the records of the proceeding.
By the executing court.
By the executing court. So today, your lordship is the executing court.
There's a difference.
Yes, absolutely. Absolutely, my lord. Today, my lord, I am moving my Section 36 before your lordship. So in the Section 36, your lordship has, my lord, your lordship has the jurisdiction to direct them to, my lord, disclose all the records before your lordship. But kindly do that so that I can come back and place all these judgments and argue this and, my lord, put it to rest. I'll leave it to your lordship then. But look, this is a very interesting point, and I found judgments on the point.
36, not in 34.
In 36, my lord. 34, I'm pressing my 34 right now.
My lord, the award, my lord, he claims that he has filed an application for enforcement of the arbitral award.
Yes.
In law, my lord, unless the award is signed by an arbitrator.
We will see that.
Yes.
Because
we
that's
will
what I
call
want
for
to
the
be
record
sure
in
before
36. In 36, we'll call for the record.
I'm very grateful, my lord. Very grateful. These are two matters, my lord.
34 we are not touching right
now. No, we are not touching. I'm not making any submission in 34.
We are not touching 34. In 36, we'll pass it.
I'm very grateful, my lord. So that I can come back and, my lord, with that information, my lord, I can make my submissions. We'll make this up.
Take down.
My lord, only may I?
Yes,
Yes,
sister. Yes, sister.
My lord, perhaps, my lord, your lordship, kindly do not take me.
No, tell me.
But as of now, your lordship perhaps would not have the jurisdiction, only in the sense.
No, why not in 36?
I'll indicate. There is the
yes,
stamp
yes.
also.
Oh, yes. No.
So it's not an award. It's not
a
signed
MSA
also.
It's a MSA.
MSA.
It's not
That is
only
why I take the
unstamped, it's
point that
unsigned.
It's an institutional arbitration. There's a judgment, my lord, of 2000.
No, but if you're challenging the award,
my lord,
you're supposed to deposit that 75%.
no, I am the, my lord.
Oh,
I am the award holder.
You're the award holder.
Part of
I
the
will
award, my
also
lord, which has not
challenge,
been-
but I
they
did
have
not get any
challenged.
award.
So that is why, my lord,
I
I'll
did not
argue
get any
they're
award.
out of
That's not
time.
an award.
Gupta, this is maintainable. 36 is maintainable if, they are the award holder.
But
Yes,
there
sir.
is no, my lord, there is no award because it's not on a stamp paper.
Now that we'll see.
It's a curable defect.
No,
See, today,
there is no stamp paper. They have sent it by an email. It's not that they have sent a different copy to us. They have
That is
sent
why,
it
my
by
lord,
an
I
email.
need that.
There is no stamp paper. There is not signed. So, my lord, anyways, I have to get a signed copy. Maybe what your lordship is thinking, subject to correction, their records may have a signed copy. Very well. I am not joining issues on that. But for me, for my time period to kick in,
I'm very
the award which is served on me, that has to be signed. That signed copy has not seen the light of the day so far as we are concerned, or my learned friend is concerned. So as of now, there is no award.
That's perhaps
So,
not correct.
and also, A, there is no signed copy given to me. B, this award is not on a stamp paper at all. That's a mandatory requirement under the Stamp Act 150 rupees. stamp
curable defect. I'll indicate that. And also, my lord, if today my learned friend is
So,
saying this,
today your lordship is exercising jurisdiction. But kindly do not take me amiss. Your lordship is exercising jurisdiction on a matter which is not yet born.
I
So
do not
they may
perhaps, my lord,
approach.
agree
They
with my
may
learned
approach
friend on
the
that.
MSME council and get this defect cured and thereafter file a fresh.
It's not really a defect, my lord, because with a certified
is a
copy,
defect.
my lord,
It is a
may I humbly submit, my lord.
see, if there's no stamp paper.
That is a curable defect. It is, my lord. I will not argue
So
on that.
curable defect.
Curable defect, definitely, my lord. But today, if my lord, it is.
So they have to cure it.
They do, my lord. But today, my lord,
have to do
where
it.
the issue which, because for their
Curable
limitation to
defect
start.
is not for this court to cure.
No, indeed, my lord.
The curable defect is for your counsel to cure.
Indeed, my lord.
So one, it's a defect. It
My
should
lord.
be on a stamp paper of 150 rupees.
Lordship.
That is something which the council has to do.
Lordship.
And second, what he's saying is also correct to the extent that
Whether it is valid service under 31.5. My lord, may I
Oh,
humbly submit on this?
see one,
My lord.
unless until the defect is cured, there's no award.
My lord, that is why, my lord,
There's no award.
I kindly, my lord, 1 minute, because today what yes.
So you have
exactly.
to write to the
today
council,
what is bothering me is, my lord, whether the original award is on a stamp paper. I do not know that.
That
This
you
is
have to find
certified
out.
copy.
You have to write to them.
Find out.
You have to write
What
to
is
them.
there with the court's record is
Can,
not.
if kindly grant us that leave, my lord, today.
I'm not
either it is
granting you any relief. I can just push it for 4 weeks.
Kindly do that, my lord. We'll come back in January. We'll be ready to, my lord, because in the meantime, we'll write to the MSME council to give this.
Whatever you have to do.
We'll do that.
Because, my lord, if a proper
Because
award is
even if
served
I
on us,
record that, I'll record all the contentions then. I'll record his contention too. And if I record his contention, then I'll dismiss it. As being not maintainable at this point of time.
My lord, perhaps I will be, my lord, trying to canvass a submission that, my lord, this.
See, till the time
I
you
understand what
don't
is falling
cure the
from my lord.
defect.
Kindly defer it by 4 weeks. And then, my lord, I'll also try and satisfy your lordship that this time limit has started from the day that certified copy has been given by email. I'll try and argue that, my lord. Because I can't improve on the facts. Whatever is there, my lord, I'll try and argue on that, because there are some judgments which say that mere intimation is enough under 31.5.
That's an award.
That's
award on a stamp
for a
paper.
certified copy.
The first and foremost hurdle which you need to
Stamp
cross
paper.
is stamp.
Indeed, my lord. I understand that. That's why I want
Till
to
the
know, my lord,
time you
from there.
don't get that cured,
Lordship.
there's no award in place.
Kindly don't pass an order today, my lord. Kindly push the matter by 4 weeks, my lord. We'll come back. In the meantime, I'll do the needful.
Kindly passes some order. I'm appealing for a public
No,
sector.
at the request of the parties. at the request of the parties, let this matter be listed after. Even in 4 weeks, you won't be able to do it.
My lord, may I? 6 weeks. 6 weeks. 6 weeks, my lord. We'll
You
come.
write to them, they reply to you.
My lord, may I only pray for this, my lord? If your lordship, my lord, keeps it after 4 weeks, in case we are not able to, my lord, we'll come and, my lord,
I
pray
have
for
no
a,
problem. I can keep it after 4 weeks.
kindly, my lord. We'll come and, my lord, pray for an extension if we feel
Better
do the
to keep it
exercise.
after 6 weeks, because even if they're going to cure it, it will take time. It's
My
not going to happen.
Lordship. I'm only, my lord, skeptical whether it is there. If it is there, my lord, then my arguments
The
change. If it is not
records
there,
will
my
be there.
arguments change.
It's just that I'm surprised they have done it without a stamp.
But no,
I
I am
think it
not
is
at all
there.
surprised. I have seen 5-6 awards. These are all like this. In commercial court, Rajarhat, on this point, 3 matters are in a limbo. Because MSME
Look,
does
there's
this.
one matter I remember
But that's why
doing
the
this.
first thing when my advocate on record came, I said, first check whether they signed. It is 5 people SD. I mean, no, it's not signed.
It is
Then
signed. That's what
there is
I'll show.
nothing
That's
is
I think
certified
both,
copy SD is enough.
both are very important, but at the same time, I mean, not having a stamp
not
paper.
having a stamp paper. None of the hours.
That's what I want to
not
know. Whether
not
actually
this
it
matter.
is
No,
there.
no, it's never
I
there.
don't.
It's
In
never
one of the
there.
matters, what has happened where we wrote to them and they disclosed that it is on the stamp paper. That's why, my lord, I wanted that prayer. My lord, made that prayer before your lordship.
At the
If this
request of
can
the
come
party,
from
list after 6 weeks.
6 weeks, my lord, we'll come back.
In the monthly list of February will be better.
My lord, may I pray for my lord 6 weeks, because if it may be lost in the monthly list then. So my lord, we come back on a
6
day.
weeks. All
6
right.
weeks. I'm very deeply obliged. Very deeply obliged. Next one. Yes.
But both matters, 24 and 25.
Both the matters. You can take this judgment back.
My lord, there's some few interesting judgments which I'll be placing in the matter. Because this is also something we had to see what is the impute of the law, my lord.
Yeah, but
Certified copy for an institutional arbitration we find is different. That's new for us, my lord. So, this is the next one, right?
This is the next one.
non-commercial.
Well, then perhaps the next matter where I'm appearing in the commercial division will be taken up tomorrow. Tomorrow I'm not there. So, my lord, my learned juniors may
We'll keep
pray
it
for
up.
an extension, my lord, maybe Monday or.
But tomorrow we won't be taking it up because it's an execution day. So Friday.
Deeply obliged.
Friday.
But instead of Friday, then can it be on Monday?
Yes, my lord. We'll come back then on Monday.
We'll see on Friday.
Matter. Item number 1.
Lordship, I'm appealing for the award holder, Lordship. The matter has been settled within the parties.
Learned counsel for the petitioner seeks to withdraw the present petition. Any communication?
Wait, Lordship, interim order is there.
No, any communication you have from the client? You want to place it on record?
We have already submitted the mentioning slip.
Seeks to withdraw the present petition. The same is dismissed as withdrawn. A copy of the communication received from the client is taken on record. The copy of the communication indicating withdrawal of the present petition is taken on record. Full stop. In view of the settlement arrived at between the parties, the petitioner does not wish to press the present in view of the settlement. Learned counsel for the petitioner has handed over a copy of the instruction received from his client, which indicates that the matter has been amicably settled between the parties. In view of the settlement arrived at, the petitioner does not wish to press the present petition. The same is dismissed as not pressed.
I am for the petition. I appeal for respondent number 4, my lord. My lord, restoration application has not been served on me, my lords.
When was it dismissed?
Yes, 13th November.
13th November?
Yes, ma'am.
My order?
Yes, yes, order. Yes, service close. It has been served. Copy the word. Number 3, national highways. I am giving copy to it.
DA1. The present application has been filed seeking restoration of the petition. Full stop. The petition was dismissed for default on 13th November 2025. Full stop. You have any objection? For the reasons stated in the application and the concession showed by the counsel for the respondent that he has no objection to the present petition being restored to its original position, the GA1 is allowed. Matter is restored to its original position.
Your lordship, please fix any date after vacation.
With the above observation, application is disposed of. Sorry?
The date is fixed, madam.
It will go in the list, whatever it is.
Your Lordship, I'm appearing for the petitioner in item number 3.
Yes.
On the last occasion, I had told your Lordship that there was a issue regarding the jurisdiction.
This is application under
Section 29A.
what jurisdiction?
Your Lordship, the
matter is already going on, right? This for extension of the mandate.
Yes, Your Lordship.
So what is the difficulty?
The difficulty is that the principal civil court under Section 21E is the Rajrat Commercial Court, Your Lordship.
The
However,
matter is already before the tribunal, right?
Yes,
If that is the problem, you file an application before the tribunal
Your Lordship,
challenging his jurisdiction. This is a 29A application.
jurisdiction of this application, jurisdiction of Section 29A application.
Who has filed it? You have not filed.
I have filed this application.
You have filed a 29A application.
Yes, sir.
And you are yourself challenging the jurisdiction.
I'm not challenging the.
What are you saying?
Lordship, there's a Supreme Court judgment that says that the court under Section 29A is the principal civil court. However,
Sir, I'm not able to understand. That is regarding the jurisdiction of the tribunal. 29A.
Your Lordship, is not regarding the jurisdiction of the tribunal, Your Lordship. It's regarding the jurisdiction of this application under Section 29A.
Under 29A.
Yes, Your Lordship. Of this court, the jurisdiction under.
You have only filed it here.
Yes,
you want to withdraw it.
Your Lordship, there is another judgment of this coordinate bench.
Who appointed the arbitrator?
This court, Your Lordship.
This court?
Yes, Your
Then maintainable. Section 11.
Yes, Your Lordship.
Section 11 arbitration.
Yes, Your
Lordship. Give me the dates.
Your Lordship, the appointment of the arbitrator was by an order dated 20th February 2024.
20th February 2024.
Yes, Your Lordship.
Pleadings are completed on?
The right to file the statement of defense was closed on 27th September 2024, Your Lordship. Your Lordship, the respondent is not appearing in the...
6 months extension?
The respondent is not appearing in the arbitration proceedings, Your Lordship. That's why by consent, there was no extension of mandate.
All right. When did it expire?
On 26 September 2025.
May I assist your Lordship?
Yes.
Though I am in the next matter, item 4, but being my Lord's officer, it's my duty to assist your Lordship.
Yes.
So far as my friend who appears for the item number 3,
yes.
What he says, that a court definition of court 29A is a court of a principal court of a having original jurisdiction.
No, he's saying 21E court would be court of principal jurisdiction, which will be the commercial court at whichever place the property is located.
So, even when this power of appointing arbitrator, so far as domestic arbitration is concerned, vests with the High Court, and international is a vest with the Supreme Court. But so far as the extension of mandate is concerned under 29A, it is only the principal civil court which can extend the mandate. And that is a dictum of the Honorable Supreme Court reported in SCC. I have argued this matter in the coordinate bench. There is also a judgment relying on
Justice Bhattacharya.
No, Justice Shampa Sarkar. And I can also give that Supreme Court judgment also, which says
NH Roadways.
Not NF Roadways, it is in the case of
PWD.
Ponchodip Construction. Construction. I myself have argued,
You come with the judgment tomorrow. We'll see it on Friday.
My Lord, today I am also out of station, but my junior is there.
To my understanding, I have passed an order. And what you are relying upon is a case of that Sikkim, where the Honorable Supreme Court, as in PhD roads, had given that 21E court would be the court of the principal jurisdiction wherever the property is located.
No, that is Lordship is absolutely correct. I have gone through. But so far as this point is concerned, the Supreme Court has made a distinction that court means, because 29A says only court. It's not. It doesn't say that High Court or Supreme Court, and that is the thing that Supreme Court has considered the issue and says that in the event the High Court is the principal civil court, then High Court can extend the mandate. But if High
So
Court is
this
not the principal
this matter
civil
is
court,
already heard by the Supreme Court. Judgment is has been reserved in November. We are still awaiting.
my lord.
Yeah, SLP number 109
Yes,
something.
yes.
I'll just give that.
Well, I have also, my lord, relying on one judgment, my lord, if your lordship, my lord, requires my
It's
humble-
10964 or something.
Yes, but this is
Which is?
It's SLP number some 0944.
and 10945 of
Yes.
2020.
44 and 45.
That is Jagdeep Chowgule versus Sheila Chowgule. And it was listed on 4th of November. After that, we have kept a keen watch. We have not been.
I'm passing this order. We'll await the outcome of the Supreme Court judgment.
My lord, sorry for my lord, my
No, thank you. No, thank you so much, Mr. Basu.
my lord, because my lord, the officer, my lord, is always
Absolutely,
my.
I'm grateful to you. Thank you.
No, my lord. The judgment that I'd be referring, my lord, my junior would supply to you, or tomorrow, my lord, I shall personally, my lord, give it to you, lord.
All right. Thank you.
My.
Grateful.
Chambo, if you can find out. If you can find out, give it to me so that I can pass it to the honorable court. My lord, in this matter, my lord, my junior is there.
Yes.
My lord, I appear for the petitioner. Now, my lord, this is a 29A. My lord, here, my lord, the High Court is the principal civil court, and I have also, my lord, made that pleading, my lord. My lord, may kindly comes to my lord, para 25 at page 11. And this is a specific pleading, my lord, being aware of the Supreme Court judgment. Now, my lord, the original arbitrator was appointed, my lord, by this honorable court at page 14 on 24th November 2022.
24th November 2022. Yes.
Lordship, page 14, the arbitrator was appointed. Then, my lord, kindly comes to page 24, minutes of the 6th meeting, where, my lord, by consent, 6 months were extended in view of a provision contained under section 29 capital A subsection 3. Because, my lord, your lordship is aware, my lord, 6 months time can be extended by the arbitrator itself on consent.
Yes.
Now, my lord, kindly comes to page 61.
So 6 months was extended on?
Extended, my lord, on 1st of February 2024 by the minutes, 6 minutes. Lordship will find at page 24. And that was about to expire on 16 February 2025, which, well, necessitated us to file a formal application under 29A capital 5. And, my lord, Lordship will find at page 61 by the coordinate bench, order dated 19th February 2025. It was extended, is a second extension.
For this was for 6 months. Huh?
6 months. Now, my lord, that period, my lord, was sometime expired on August 2025. Interregnum, my lord, we have filed this application, and, my lord, kindly comes to page 118, the last minutes held by the tribunal, where the tribunal also recorded that the parties consented. My lord, lordship kindly comes to 118.
Yes.
Where the parties have gave their consent for the further extension, my lord, and it is in the stage of, my lord, examining, my lord, the respondent's first witness. Claimant examination, my lord, witness action is over. Respondent, my lord, first witness, my lord, is being cross-examined by me, is about to be over, my lord, within 1 or 2 days. They say they may produce one more witness, and thereafter the matter will proceed for argument. And, my lord, if your lordship kindly comes to, my lord, page 11, my lord, kindly see para 23, 24, 25. 23 with regard to purpose of filing this application. 24, my lord, we say, my lord, there is, so far as the delay in the proceeding, my lord, is not intentional, my lord, which is a requirement of 29A. And 20.
The mandate expires on 20th August.
20th August. 20th August. Lordship is absolutely correct. And 25, my lord, we say that your lordship court is the principal civil court in terms of section 2. I'm grateful.
The petitioner has filed the present application seeking extension of the mandate under section 9A for conclusion of the arbitral proceedings and publication of the award. Full stop. It is the contention of the learned counsel for the petitioner, Mr. Basu, contends that the arbitrator, the sole arbitrator, it's a tribunal or a
sole arbitrator.
That the sole arbitrator was appointed
sole arbitrator
by this court-wide order dated 24/11/2022 to adjudicate the dispute between the parties. Full stop. He further states that the extension, the consent, the extension by consent for a period of 6 months was granted on what was the date of that order? 21st. On 21st.
It was not an order, minutes by the arbitrator, 1st of February.
The minute,
page 24.
Extension. The 6 months extension was
yes
granted by the tribunal on 21st February 2024.
1st of February.
1st of February 2024.
My lord.
Full stop. He states that he had approached this court seeking further extension on 19/2/2025. Full stop. This court-wide order dated, he had approached this court, further he had approached this court for the second extension. Full stop. This court-wide order dated 19/2/2025 had granted an extension of 6 months to the tribunal to conclude the proceedings. Full stop. The extension, the mandate of the tribunal expired on 20th August 2025. Full stop. 20th August 2025. Learned counsel for the petitioner further states that the matter is at the stage of recording of evidence of the respondents. Full stop. The tribunal has already held how many sittings?
Last sitting was 38.
The tribunal has already held more than 30 sittings. Full stop. None appears for the respondent despite service. Full stop. Upon consideration, this court is satisfied that there has been no undue or unwarranted delay on part of the arbitral tribunal in conducting the proceedings. Full stop. In view of the advanced stage of the proceedings and in the advanced stage of proceeding, this court is satisfied that the mandate of the arbitral tribunal shall be further extended for a period of how much time you want?
I leave it to your lordship wisdom, my lord.
How much you have asked?
My lord, I say that lordship wisdom, my lord, whatever permits. My lord, may I just check the prayer, my lord?
I think you have not asked any.
No, my lord, we haven't.
No, I say, man, it's upon the terms and because it's 29
8 months.
My lord.
To conclude the arbitral proceedings and publish the award. Full stop.
Extremely grateful.
It is requested. The learned sole arbitrator is requested to adhere to the timeline. With the above direction, the present application is disposed of.
I'm extremely grateful.
Deeply obliged.
Much obliged.
Lordship, I am appearing for the petitioner. On the last occasion, my learned senior friend raised one point regarding commercial and non-commercial. Perhaps Lordship can remember the situation. If Lordship, I have to withdraw, otherwise Lordship can transfer. Suppose it is not possible, I have to withdraw as with liberty to file appraise.
You can withdraw it.
Yes,
This extension.
absolutely.
You can withdraw it. Learned counsel for the petitioner seeks to withdraw the present petition with liberty to file appropriate proceedings in accordance with law. Liberty is granted. The present petition is dismissed as withdrawn.
Deep. I'm due.
Well, in my 29A application, the arbitrator was appointed by an order of 5th of January 2023 of this Honorable Court, my lord. Thereafter, my lord, arbitrator had entered upon.
Just a minute,
I'm sorry.
When was he appointed?
5th of January 2023 is a Section 11 order. And my lord, pleadings were completed on 15th of May 2023.
6 months?
6 months, my lord, extended. 16th of May 2024, my lord, 6 months were extended. And this was, my lord, the extended period went on. And thereafter, my lord, 21st 29A was filed and an order was passed on 25th of March 2025. My lord will find that order at page 23. This was extended by 8 months and that 8 months period expired on 24th of November 2025. Stage of final argument, claimant submissions concluded, respondent had commenced his arguments.
All right, take down.
Affidavit of service, we have served.
Affidavit of service taken on record. None appears for the respondent. Full stop. The petitioner has preferred the present application under Section 29A of the Arbitration and Conciliation Act, seeking extension of mandate of the arbitral tribunal for concluding the proceedings and publication of the award. Full stop. It is a case of the petitioner that the sole arbitrator, the learned sole arbitrator was appointed by this court by order dated 5/1/2023. Full stop. The pleadings were completed on 15/5/2023. Full stop. The parties by mutual consent sought an extension before the learned arbitrator. Full stop. The learned arbitrator had granted extension till 16/5/2024. Full stop. The learned counsel for the petitioner states that an application for seeking extension of the mandate was filed before this court under Section 29A. Full stop. This court, by order dated 25/3/2025, had granted an extension of 8 months to the learned sole arbitrator to conclude the proceedings. Full stop. Learned counsel for the petitioner states that the arbitrator has already held more than
60 sittings.
60 sittings, and the matter is at the stage of final arguments, and that the evidence has already been concluded. Full stop. Considering the facts and the arguments raised by the learned counsel for the petitioner, this court is satisfied that there has been no undue or unwarranted delay on part of the learned sole arbitrator in conducting the proceedings. Full stop. It is noted that the matter is already at the final argument stage, and that in the interest of justice, the mandate of the arbitral tribunal is further extended for a period of 6 months.
6 months.
6 months. 6 months. Full stop. 6 months to conclude the arbitral proceedings. Full stop. Learned sole arbitrator is requested to conclude the proceedings and publish the award within the extended time period. Full stop. With the above aforesaid direction, the present petition is disposed of.
Grateful, my lord.
Seven, Your Lordship, I appear on behalf of the petitioner. The arbitrator was appointed by way of an order dated 20th of February 2024 and had entered reference on 7th of March 2024. The pleadings were completed on 10th of June 2024. The 1-year time period came to an end on 10th of June 2025. It was extended by mutual consent of both the parties on 20th of May 2025 for a further period of 6 months.
When was it extended?
20th of May 2025. By consent, it was extended for a further period of 6 months, which came to an end on 10th of December 2025. The stage is the claimant's witness has been examined in full. It's the respondent's witness examination which is going on. There have been more than 27 sittings held.
27.
27, Lordship.
Affidavit service is taken on record. Despite service, none appears for the respondent. Full stop. This is an application filed by the petitioner under Section 29A of the Arbitration and Conciliation Act, seeking extension of the mandate of the arbitral tribunal to conclude the proceedings and publish the award. Full stop. Learned counsel for the petitioner states that this court-wide order dated 20/2/2024 had appointed the learned sole arbitrator. Full stop. The pleadings were completed on 10/6/2024. Full stop. By mutual consent, the mandate of the arbitral tribunal was extended for a period of 6 months on 20th/5/2025. Full stop. It is further submitted by the learned counsel for the petitioner that the said extension comes to an end on 10/12/2025. Came to an end on 10/12/2025. Full stop. Hence the present application. Full stop. Upon consideration, he further states that there have been more than 27 sittings held by the learned arbitrator. Full stop. Upon consideration of materials on record and the submissions made by the learned counsel for the petitioner, this court is satisfied that there has been no undue or unwarranted delay on part of the learned sole arbitrator in conducting the arbitral proceedings. Full stop. In view of the fact that there are more than 27 sittings already held by the learned counsel for the arbitrator, and that the matter is at the stage of examination of the claimant's respondents' witnesses, this court feels that the present proceedings are at an advanced stage, and in the interest of justice, the mandate of the arbitral tribunal
8 months if possible.
is extended for a period of how much have you asked?
So my prayer is 6 months or any further period that your lordship may.
8 months to conclude the arbitral proceedings and publish the final award. Full stop. Learned sole arbitrator is requested to adhere to the timeline extended by this court. Full stop. With the aforesaid direction, the present petition is disposed of.
Grateful, lordship.
My lord, before my learned friend begins, I have a very humble short prayer. If my lord keeps the matter tomorrow, I am opposing an injunction application which will be heard just 1 minute after my lord.
My submission
Only
is complete, your lordship.
keep it tomorrow, my lord.
Why we were keeping it last time also?
Yes, I was not there.
What happened?
Kindly keep it tomorrow, my lord. I assure your lordship.
Kindly, my lord,
I am
consider our
opposing an
position
injunction.
before the my lord executing court. They have attached my bank account. My lord.
Tomorrow, the date is not there. Tomorrow, 1 day accommodation.
Your junior counsel is asking. Tell me.
Your lordship kindly fix that item number 1.
Injunction page.
কিন্তু এখানে লোয়ার কোর্ট
কালকে আছে
আজকে আছে এখন
হয়ে গেছে it's already the day is over. The day is over, my lord. Tomorrow.
That's very unfair that you are getting his bank account attached.
Nothing. It's fair, my lord. There's an award against him. If kindly keep it tomorrow, my lord, 3 o'clock, 10:30, anytime I will come and do the matter.
No, but you sought this extension on couple of occasions.
No.
Last
It was heard many times, my lord. There was change of determination. The matter appeared before my lord.
For me, it has appeared couple of times.
No.
This is second time.
Second time.
Yeah, second time.
Before the lordship, this second.
Kindly keep it tomorrow, my lord.
Third time.
Only 1 day's accommodation.
And may I pray only this prayer? Let him do whenever he. My lordship kindly restrain, my lord, the court below, my lord, not to proceed
that would
further.
be allowing. That cannot have. Tomorrow.
I have to hear you for that. Tomorrow.
Tomorrow as item number 1 or
3 o'clock. Yes,
Keep it
I am
as
agreeable.
Item 1.
Item 1. Great.
May please, Your Lordship.
Your Lordships,
I'm appealing for the respondent in the matter.
I'm being led by Mr. UP Singh, Senior Advocate, Your Lordships.
Yes.
He's unwell. He's requested if it could be fixed for 19th, Your Lordships.
May I only submit
January,
this? We are an MSME entity, my lord. There's an award in our favor. My lord, they have not made the pre-deposit of, my lord, 75%, which is a mandate from the year 2023. They have filed. So, my lord, today, I'm only praying for, my lord, one relief today, which my learned friends will not be in a position to oppose. Your lordship will kindly find that there's a AP 757 of 2023, that is the section 34. Today, my lord, this section 34 is non-est in law because they have not made the mandatory pre-deposit of 75%. They have not done that, my lord. Now, today, they file an application, which is, my lord, GA2 before your lordship in AP 757 of 2023. The prayer is very interesting. They pray for waiver of this 75%. I'm carrying, my lord, judgment of India glycols, where the Supreme Court has said this is, my lord, a mandate. Can't be waived. I'm only praying that GA2 be dismissed today. Because they don't have an answer to this.
Withdraw it.
My lord,
Withdraw your application.
lordship.
Withdraw GA2.
And this has been going on, my lord, because I wouldn't have otherwise opposed, my lord, the adjournment. 21's award, my lord. Award is, may I only indicate this, my lord. 12th May 2021 is the award. They don't file a section 34 within 120 days. They file, my lord, a writ petition challenging this award, and that writ petition is filed after almost 2 years. My lord, the Honorable Writ Court dismisses this, but grants them a liberty that you can approach the section 34 court. If you approach the court within 7 days, then we will construe that it is filed within time. My lord, we prefer an appeal therefrom. We, my lord, in the appeal, we succeed. Those two observations that, my lord, this will be construed as something filed within time is set aside by the Honorable Division Bench. But the Honorable Division Bench relegates the matter to the section 34 court, where, my lord, with the direction that the court will decide on the issue of limitation. My lord, when it was first taken up, the issue of limitation was only, my lord, considered, where I had, my lord, indicated that there is no 75% pre-deposit. They had not made the deposit even then. My lord, unfortunately for us, in that proceeding, my lord, we could not succeed because of, my lord, the Honorable Court holding that this will be construed as being within period of limitation. We filed an SLP from them. SLP got admitted. I went, my lord, I argued. It was admitted, notice issued. Second day, my lord, I could not go because of some reasons, and, my lord, the lawyers there had appeared virtually. I was not there. There was a technical glitch. The Honorable Court asked, is there any merits you think this is to be, my lord, gone ahead with? My lord, my learned, my lord, counterparts there. In fact, the lawyers appearing for the respondents had said that we have filed our affidavits, kindly give them a chance to file their response.
Dismissed.
Well, when this question was posed by the Honorable Bench, my lord, at the first instance when they appeared, they said, I am appearing. The answer came when the
admitted now.
only this reason, my lord, the SLP got dismissed.
So your limitation issue is taken.
Limitation issue, I'm not arguing. My lord, today what I'm on is without, today they have filed a 36-2. 36-2 with 2023.
36-2 right now is a stillborn baby.
It's a stillborn. I'm very grateful. Kindly dismiss it, my lord. That's my prayer.
Lordship, in this regard, I pray for only adjourn the matter and fix on 19th or for hearing of the GA.
My lord, may I only pray for this. Today,
At 3 p.m. Lordship, because the
I'm only praying
time, and
today the figure is,
in the-
may I indicate this to my learned friend also, today the figure has come up to 3 crore. What is the exact figure? 2 crore. We have 2 crore 5 lakhs 67,000. The principal sum was 36 lakhs. They have not paid this. 3 times interest comes to today, my lord, 2 crore 5 lakhs odd, and they are still not paying it. Today there is no section 34 in the eye of law because, my lord, they have not made that 75% pre-deposit.
This is what Bihar Medical Services.
Yes. So I will take it, Lordship.
Who pays all this
Yes. But I will take
Yes. Wait a minute. Who pays all this money?
Lordship.
All this interest, who pays?
That
Taxpayers.
Taxpayers.
Lordship, I will take instruction from my client. So kindly adjourn for few days and kindly
Dismiss everything.
I'm very grateful.
There's no point. These kind of petitions should not be entertained.
We are being harassed, my lord. That's the only
This is
difficulty.
harassment. Not only harassment. This is taxpayers' money.
We are an MSME entity, my lord. We're not getting what, my lord, is
sell all their properties, file an execution petition, get everything auctioned and sold off.
But may I only hand over this? This is a recent calculation to keep kept on record.
Lordship, kindly give me one one chance. My senior is will argue the case. He's not well, so
Your
kindly
senior is not well. Friday, not more than that.
Have a copy of
this
it,
Friday.
so that-
This Friday.
This Friday. Who's your senior?
Lordship, Mr. UPC Umesh Prasad Singh, senior advocate
Tell him
from
to be here.
Patna.
Friday. Friday.
Friday.
Lord, may I
These kind of petitions are absolutely frivolous. They should not be entertained at all. ये Friday ऊपर रखना, so that we can dispose it off. This has to go.
My lord, may we hand over the recent calculation? I'm also handing over to my learned friend so that, my lord, they can, my lord, because this is the exact amount which, my lord, as on.
You have not filed execution.
We filed an execution.
Where there?
Right here, my lord. Unfortunately, because we did not know their assets. So now, my lord, they have disclosed that their assets is in Bihar. So, my lord, today.
File over there, get it.
We will, my lord, we will. But, my lord, this application has to go, my lord. This
They have
section
filed the
34 has-
exclusion application as a exclusion application number 5 of 2024, which is
That's
pending
item
before.
number 14. Well, that's item number
Right.
14, my lord, today's list. So 9, 10 is this, my lord, and 14 is our execution, my lord.
9, 10, 14 all listed together.
My lord. And but we have handed over a copy of the calculation to my learned friend, my lord.
9, 10, 14 on Friday. At least make the payment.
Yes.
At least deposit the
fixed.
money. It's your money. Do you pay income tax?
Yes.
I'm sure you do.
Yes.
Then you're gifting it to him.
He is taking our money as well, my lord. We also pay tax, my lord.
It's so sad, I tell you.
So on Friday,
Very
we will take.
unfortunate. I'm very deeply
It has
obliged.
become a business, I think. MSME is a business.
Very unfortunate. my lord.
42 lakhs goes to 24 crores. How much is yours?
My lord, 36 lakhs, which comes up to
36 lakhs
2.5
goes
lakhs
to
now.
2.5 crores.
And from 2021, we are not getting the money.
We should all open a MSME company, get an award for 5 lakhs, then live off it for the next 10 years. Every month, the government will keep paying us. And no one is bothered.
So we'll come on Friday with my senior.
I never knew this kind of business also can flourish.
The struggle is with the MSME entities, my lord. They are not very cash rich. But with that, my lord,
I honestly, that is the whole intent of the act, that since they're not.
my lord. We'll come back. Deeply obliged.
Next.
Lord, this is that matter. If your lordship remembers, my lord, it's come after a long time.
My lord,
I had taken the plea that, my lord, the section 36(3) itself has been filed on the wrong side of this honorable court. Instead of on the commercial division, it's been filed on the ordinary original side.
My lord, in this matter, Mr. Ajit Kumar Mishra is appearing on behalf of the petitioner, my lord. My lord, due to a sudden demise in his family, my lord, he has went-
Withdraw it, file it in the right side.
My lord, I do not normally come in the way of any adjournment. My
Kindly-
lord, this is with a very difficulty. This matter has come up again, my lord. And my lord, it's been almost more than 2 decades. My client is suffering.
My lord,
Notice of
kindly keeps it on,
2007 award passed in
24th, my lord.
2023, my lord.
Because he has went to his native place, my lord, to attend the ceremonial rites, my lord.
My lord, the section 21 notice was issued in 2007. Milord, the railways had taken 2 decades to constitute a tribunal, finally award in 2023. And Milord, kindly see the situation.
So file for execution.
Milord, I have filed, Milord, but they have taken the undertaking that we'll file a stay. My Lord kindly grants it. That happened in May, and today, Milord,
No
we are
stay.
listening.
Where's the stay?
Milord, there's no stay, but Milord, because they are government, so Milord, in the last order also, there's an undertaking given that they'll move it. Therefore, the executor may wait for some time. That's the observation in the order. So therefore, even I have kept quiet. But Milord, if this keeps going on, Milord, how will my client, Milord, get
No,
payment? He's not
there's
even
no
an
stay.
MSME,
There's no
Milord.
order which has been passed here. You can
Milord, it's
go ahead
appearing
with
as
the
item number 615 in your lordship's list, Milord, on the commercial division.
We'll see that.
And Milord,
What is your prayer? You
Milord,
filed it
Milord,
on the wrong side.
Milord,
Either you withdraw it.
Mr. Mishra will make his submissions, Milord.
Tell Mr. Mishra to join in.
Kindly keeps it on 24th, Milord. He will argue.
24th? 24th is a holiday. Only Mr. Mishra will work on 24th.
24th
Last working day. 20.
Working days he doesn't want to work. Holidays he wants to work. Huh?
Milord, can we come back on 19th, Milord?
9. Milord, kindly keeps it on 23rd then.
You want an effective order? Let it go in January.
Lord, may I only make
6th
one
of January. Better for you. 6th of January.
Much obliged. I'm done.
But
At
may I
the
only
request of the
make-
learned counsel of the
Yes,
petitioner that proxy counsel so and so states that the main arguing counsel is
Great.
indisposed. Let this matter be listed on 6th of January. It is noted that even on the earlier occasion, there was no appearance on behalf of the petitioner. It is expected that the petitioner will address this court on the next date of hearing and will not seek any more adjournments. List on 6th of January.
I'm great.
Yes. 13.
13, Milord.
In item 13, Milord, I am for the Milord, the petitioner. This is my application.
I am the petitioner in the main section 34. The respondent has taken out an application, Milord, for renewal of their bank guarantee. Milord, here there was there was a stay
Milord, my
granted.
application, may I please?
No, I'll just indicate why. Acha, let my
Milord, my application, Milord, seeking permission.
No
to-
jurisdiction issue, Mr. Mukherjee. Huh?
no further, Milord. One is enough for the day.
No, no, just to Milord to furnish the bank guarantee, Milord, which was expired, Milord. And Milord, the reason is that Milord, there has Milord in the interregnum period, Milord, there has been change in the management and the name of the Milord the company, Milord. Milord, initially it was Medica Hospital Private Limited, and now Milord it is Milord Manipal Hospitals.
Is that the application? You have moved a show me the
Milord, I
application.
am the award.
What is this GA?
GA Milord 2.
This is a GA2, right?
IA number 2. IA GA number 2 of 2025.
I'll just show only this one. Long class. Correct.
For leave to file bank guarantee by the respondent. Change number based on fresh.
And
So you want two things. Basically one thing, but
one thing.
One thing which is
Just
so innocuous as what my learned friend
yes,
indicated.
it is not.
Let him come.
Milord, initially, Milord, Milord, may I place Milord? Milord, at page 9, Milord, Milord, the incorporation certificate, Milord. If
Page 9 is the new incorporation certificate.
Milord, initially it was Medica Hospital Private Limited, now it has been changed to Manipal Hospital, Eastern India Private Limited. Now, Milord, if Milord may kindly take to come to page 10, Milord. Milord, I hurriedly go through Milord the orders, Milord.
Page
10, Milord.
No,
Milord,
take your time. Don't be in a hurry.
No. Page 10, Milord. Milord, the awarded amount is 1.26 crore, Milord. And Milord, the The petitioner, the Ohio Cardiology Association, the award data was directed to deposit rupees 1.26 crore with the register original site. And that is the awarded amount. Now, thereafter we filed an application for taking that money by furnishing our counter guarantee. At page 12, is the order. By order dated January 16, 2023, our application was allowed. We were allowed to withdraw the awarded sum that was deposited with the learned register original site, and after furnishing our counter guarantee. The counter guarantee was furnished. Thereafter, the counter guarantee expired. We seek leave of this honorable court. Again, we furnish the counter guarantee. The counter guarantee expired on 25th of September 2024. Thereafter, we filed this application.
When did it expire, the bank guarantee?
The bank guarantee expired on 25th of September 2025. 2025, at page 27. No, 27. Just before the vacation,
yes.
And we have taken up the fresh bank guarantee at page 24. The draft fresh bank guarantee. And the original with us,
fresh bank guarantee is page?
At page 24, The original, we are retaining the original, we will furnish it with the learning register if my application is allowed. But the difficulty is not that
it is in the name of Manipal only, the last one which has expired.
Last one, they are seeking. This is the proposed bank guarantee that they want to file.
No, page 27, the last one which got expired.
Yes. Manipal Eastern is the new name. Initially, it was only Manipal.
Manipal Hospital Eastern India Private Limited.
Yes.
It's the same name.
Yes.
This time also they are seeking the same thing.
They are seeking an extension of time. That is what I'm opposing. I'm not on the name. Name change is fine. I have no difficulty in that.
Extension of time.
I'll indicate that. If my learned friend has concluded, I'll just indicate in 2 minutes.
No, let him finish.
Yes.
Initially, it was Medica Hospital. Initially, it was Medica Hospital, Private Limited. Thereafter, there has been a takeover of the entire company. There has been
then Manipal Hospital.
Manipal Hospital now taken over.
That's fine.
And thereafter,
so last time also it was in the name of Manipal only.
It was it was requested that the Manipal, but Medica was there. Management of the Medica was there.
Sir, you please have a
I'm
page 27.
I'm bowed on what it's falling from your lordship,
Please see the same name, Manipal Hospital Eastern India Private Limited. This is what it was. Page 27, the bank guarantee which has expired.
I have been instructed that, this is...
So today also is the same thing.
No, I have been instructed that, page 24, it starts from page 24. This
so 24 is a new one.
It's the continuous draft, bank guarantee,
This is
page 27 is a draft, It's a draft. It's taken out on September 22, 2025, At page 27, top, It's
no, but then that might be a copy.
But that's a draft copy.
But that was already there on record.
No. This is we will furnish the entire thing.
Perhaps what has happened,
page 24 to 27.
They've gone to the registrar with this. Registrar perhaps has not accepted it because of the change of
They have
name.
not accepted.
Perhaps that is what he's trying to say. This is 2025. 24 is the first page. 24 is the first page of the bank guarantee. That is followed by the actual bank guarantee on the stamp paper. If the original is there, it will be evident. 24 is on plain paper, and thereafter the bank guarantee itself is 25 to 27. I think that is what has happened. That's the bank guarantee on the stamp paper, and the first page is the covering letter that is at page 24. Perhaps that is what has happened. Yes. But I am not on that. Change in name is perfectly fine. I have no objection in that regard.
So there's a problem with page 27 because that's expiry. There's a problem with page 27.
Expiry date, because page 24, the expiry date is 25th of September. It has to be 25th of September 2026.
Original will have to be reported. That can be sorted out. Name, I am not joining issue. I am joining issue only on one thing. Page 13, if Malad kindly takes of the application, That's the order by which they were allowed to take out the money from the register. Here, my lord, I am the award debtor. I had secured the entire award itself by depositing the full amount in cash. They took out the money, page 13, my lord, the second last paragraph only I'll place. I will make it clear they are permitted to take out the money subject to a counter guarantee. Now, with this condition, I will make it clear that the aforesaid bank guarantee must be renewed each year with an increment of 5% at least 1 month before the scheduled date of expiry. So they had to take steps. If September is expiring, they would have had to come in August at the very least to take steps. Now here, this is the first time. Thereafter, they breach this condition. Well, I will kindly take page 22 once. Page 22 at page 23. I'll take Muller directly to 23. They had filed a previous application for 24-25. The financial year 24-25, they filed this application. Muller will kindly see this order is passed. Lord learned so and so. Lord will kindly see the second last paragraph at page 22. In view of the above, the delay in submitting the bank guarantee is condoned. The registrar shall accept the renewed bank guarantee by construing the same in time. Next page. Lord, however, this is a one-time concession made, and in the future, the petitioner shall comply with the order dated 16 January 2023, renewing the bank guarantee at least 1 month before the scheduled date of expiry. Today, this is a one-time, the order is very clear. It is a one-time exemption that is granted.
Yes, sir.
Milord, kindly, Milord, take page 9 once.
Where are you seeking the extension?
Milord, I will
Where
be
are you seeking the extension of time?
Milord,
where's the prayer for that? Show me from the application. This contempt, I'll send your directors to.
No, Milord, Milord, I can
for some
justify,
time.
Milord. I can.
They'll be
justify,
happy. Doctors, huh?
If Milord may kindly take page 9 once, Milord, why Milord the delay, Milord? The delay is
I don't
that
want to hear the delay. I'm not into the issues of delay. Why there's a delay is none of my concern. There shouldn't be a delay is my concern.
Milord, the incorporation certificate has been issued on 26th
Sir,
of November, Milord.
Whatever it is,
After, Milord,
whatever it is, you should have kept it in the name of the previous company, and only once your certificate of incorporation has come, you should have put it in this company's name. Delay can't be contoned on this ground at all.
no, Milord, there has been, Milord, I admit, Milord, there.
All right, you move an application.
Milord,
move an application.
We will kindly not pass any order here. We'll take out an application.
You take out an application. I am not going to allow this.
Milord, the delay, Milord, is explainable, Milord.
They think they can take the court for a ride.
Milord,
Huh?
the delay has been, Milord.
When there's a specific direction which has been passed by the court that they are supposed to deposit the money, you have already withdrawn the money. You are supposed to deposit it before a month, and you keep on flouting the orders passed by this court.
Milord,
One concession has been given. Time and again you will be seeking, and this time you have not even sought the concession.
Milord,
where's the concession sought? Where have you prayed for it in the application?
Milord, prayer Milord, for liberty, Milord, to
Where's
the
the
applicant can be granted with liberty to deposit the bank guarantee issued in the name of Milord.
Where have you sought the condonation?
Milord, court can Milord mold the Milord of prayer, Milord, at any time, Milord.
Why should I mold the prayer? I should send you. You guys.
I have Milord taken out an application as and when Milord is failed. Milord, in fact, Milord, the guarantee has been Milord taken out Milord prior to expiry, Milord. We furnished Milord. Thereafter, Milord, the department.
You can't do that, sir. Sorry. You're violating the orders of this court.
It has been Milord taken out on 22nd of Milord September, Milord.
3 days before expiry, he takes
But the Milord kindly Milord.
1 month before the expiry, you have to furnish the bank guarantee, which you're not doing it.
Milord, kindly make it Milord. This time, Milord, from next. Milord, in fact, Milord, the section 34, I'm ready, Milord. Let us argue.
Why should I get into section 34? That is a different thing altogether. Your conduct doesn't inspire any confidence. Let them move an application.
Milord, let them file an opposition to this application. Milord.
Opposition? Then I'm telling you, I'm not going to leave you.
No,
I'm have to file an opposition.
Milord.
We can file, but
I'm at your lordship.
Not allowed.
I am not, Milord.
We'll take out an application that will move it whenever it comes up. We'll move it.
Let it be Mr. Mukhopadhyay this time.
Milord, I am at your lordship, but I am not.
Only one thing I'll just indicate: the certificate of incorporation is also 2024, my lord. So that is not also a ground. Certificate of incorporation is of 2024.
I know there's no ground at all.
No ground at all. Yes.
This is an application filed by the award.
Award.
Lord, award is dated, my lord, 30th of December 2021.
The award letter.
I'm the award holder.
Award holder.
He's the award holder.
The application has been filed by the petitioner, the award holder, seeking a direction on the registrar original site, High Court Calcutta, to accept the bank guarantee in the change name from Medical Hospitals Private Limited to Medica. It should be Medica, right?
Medica.
Medica, not Medica.
Typographical
Medica
mistake. Medica
Hospitals
Hospitals.
Private Limited to Manipal Hospitals, Eastern India Private Limited. He further seeks liberty to deposit the said bank guarantee in the name of Manipal Hospital Eastern India Private Limited, full stop. Within private limited within 7 days from the date of passing of the order, full stop. It is the contention of the learned counsel for the petitioner that the company has been changed from Medica Hospital, that the name of the company has changed from Medica Hospital Private Limited to Manipal Hospital Eastern India Private Limited, and a certificate of incorporation pursuant to change of name issued by the Ministry of Corporate Affairs dated 26/11/2024 has been placed on record, full stop. It is further pointed out that this court, by order dated, which was that order which you had pointed out?
Yes, that's at page 12.
16th of January.
16th
By order
January
dated,
2020.
which
16 January 2020. No, that's the last one. 16 January 2023.
16 January 2023
Yes,
had
permitted the
indicated that the bank guarantee must be renewed each year with an increment of 5% per annum and at least 1 month before the scheduled date of expiry, full stop. Learned counsel for the respondent states that the said order has been violated by the petitioner and the bank guarantee has not been renewed on time, full stop. He further points out that similar action was earlier done by the petitioner, wherein they had failed to renew the bank guarantee within a period of 1 month, as indicated by this court in its order dated 16 January 2023.
30th September. Second occasion.
The said action was condoned by this court in its order dated 30th September 2024, wherein the court had made a one-time concession and had directed the petitioner to comply with the order dated 16th January 2023 by renewing the bank guarantee at least 1 month before the scheduled date of expiry, full stop. Learned counsel for the petitioner states that the said act will not be repeated in future and that as a one-time measure, this court may condone the action of the petitioner, full stop. Though this court notes that the petitioner has been flouting the orders of the court, but as the counsel for the petitioner has undertaken that the order dated 16 January 2023 will not be flouted in future, this court condones the delay in renewing the bank guarantee. The Registrar General is directed to take the same with the changed name within 1 week from today. Full stop. With the above direction, the present application is disposed of.
One further, in case they don't comply with it, Malad can include it. Malad,
In case the said direction is not complied with, the stay directed. What is the date?
The registrar is
4th of Malad.
no, Malad stays in my favor. The registrar can be directed to invoke the bank guarantee and
In case there's no bank guarantee right now. How can he invoke? That's against you. That doesn't help you.
Grateful.
Public.
We'll take out application.
Yes, so amended.
With the above direction, the present application is disposed of. GA. The other matters now.
Next matter in the combined list, monthly list 16, item 16, it is my matter, section 34. It is of 2016.
Show me.
My lord,
2016?
2016 matter.
We'll
That
hear
is
it.
why otherwise I would not have started your lordship at this
start
again.
And for
My
the
lord,
railway authority.
my lord, my claim, entire claim has been, my lord, rejected. Award, nil award on the ground.
How many volumes?
Only one.
One.
Okay. Start.
And one affidavit was filed annexing all the claims, statement of claim counter. My lord, my claim, learned arbitrator, my lord, awarded nil amount on all the claims on the ground that I signed the final bill with no claim certificate. That I have no claims, no claim against in future. My lord, there I am covered in this respect, my lord, I am covered by several judgments that if other claims are there, then no claim certificate will not be debarred, will not debar the claimant, contractor, to raise their claims before the arbitrator, and the arbitrator should decide that. If your lordship kindly turns straight
Start
away,
from page 61.
page 61.
You are for the respondent?
Page 61.
Yes.
Last paragraph, that the above tender work was awarded so and so, so and so. Then we may come to the page 62, next page.
34 supplementary agreement with Chaitanya being the contractor, DOC contract was expired on after giving 7 no extension.
Here also, next last paragraph, the claimant contractor, may I place before lordship?
I claim some amount.
Chaitanya,
Some items which were included, not in the executed contract agreement. It is outside the purview of the contract.
I had to do this, my lord, under their instruction, and I requested
The document submitted by
my lord before the learned arbitrator for a direction
the incident contract
that the respondent should produce
and sign the following as following.
the site order book.
Again, as per the condition of the contract will be done. No merit in no claim certificate. Yes.
If your lordship kindly takes this voluminous affidavit, supplementary affidavit filed in terms of the liberty given.
Yes.
My lord, I have, my lord, annexed there in my rejoinder.
Yes.
I have that rejoinder is annexed here too. And my lord, at page 131 of that affidavit, I have given the pages of the site order book where from it will appear that I have done this work, and the respondent authority also duly signed day-to-day execution of the work. Page 131 starts day-to-day execution.
No, that is not the issue. The issue is very simple here.
Yes.
You have signed a no claim certificate. On that basis, the arbitrator has not awarded you anything. Now you show me how do you overcome that?
How?
How do you overcome it?
Overcome. I am, my lord, because it is outside the scope of the contract.
Yes.
My lord, there are two judgments I rely upon. That.
Show me, sir. Well, that's the only point of consideration, nothing else.
But before that, if you lordship kindly turn to page 129.
Yes.
It starts that this is the extra work register as per order of senior DN, page 129.
See, sir, all this will be futile if you yourself has given a no claim certificate.
No, yes. No claim certificate.
I have annexed in my
will be relying
opposition their
upon
no claim certificate. In
two
my
judgments.
opposition, I have annexed.
One is, my lord, I'm just placing your lordship. One is 2011 to paragraph 10, 11, and 13. 10, 11, and 13. Paragraph 10 says, before going into the factual metrics in this aspect, it is useful to refer the decision of this court relied on by Mr. Altaf Ahmad in NTPC Limited versus Rashmi Construction, Builders and Contractors, which relates to termination of a contract. One of the questions that arose for consideration was whether after the contract comes to an end by completion of the contract work and acceptance of the final bill in full and final satisfaction, and after issuing no demand certificate by the contractor, can any party to the contract raise any dispute for reference to arbitration? Then, my lord, set out in that
But
part.
this is not the only point. In your case, there are two things. One, the agreement from which these contracts are arising are not part of the subject matter of dispute before the arbitrator. And second, no claim certificate which has been issued by you.
The second part is covered by this judgment.
Let us see this.
Yes. Second part. First part I will deal with, lordship. Even the rights and obligations of the parties are worked out. The contract does not come to an end inter alia for the purpose of determination of the dispute arising thereunder, and thus the arbitration agreement can be invoked, although it may not be strictly in place. But we cannot shut our eyes to the ground reality that in a case where a contractor has made huge investment, he cannot afford not to take from the employer the amount under the bill for various reasons, which may include discharge of his liability towards the bank, financial institutions, and other persons. In such a situation, the public sector undertakings would have an upper hand. They would not ordinarily release the money unless a no demand certificate is signed. Here also it has happened. I'll place before lordship the particular document that we are, my lord, bound to sign. I will place. Each case, therefore, is required to be considered on its own facts. Then, my lord, paragraph 11, next page, 405. In Ambika Construction versus Union of India, which also deals with issuance of no claim certificate by the contractor, the following conclusions are relevant, which reads as under. Since we are called upon to consider the efficacy of the clause 43.2 of the general conditions of contract, here also 43.2, with reference to the subject matter of the present appeal, the same is set out here under 43.2 of the general conditions of contract. Then, my lord, here the 43 says, The contractor shall not be entitled to make any claim whatsoever against the railways under and by virtue of or arising out of the contract, nor shall the railway entertain and consider any such claim if made by the contractor after he shall have signed a no-claim certificate in favor of the railway in such form as shall be required by the railway after the works are finally measured up. The contractor shall be debarred from disputing the correctness of the items covered by no-claim certificate or demanding a reference to arbitration in respect thereof. A glance at the said clause will immediately indicate that no claim certificate is required to be submitted by a contractor once the work is finally measured up. In the instant case, the work was yet to be completed and there is nothing to indicate that the works as undertaken by the contractor had been finally measured, and on the basis of the same, no claim certificate had been issued by the appellant. On the other hand, even the first arbitrator who had been appointed and come to findings that no claim certificate had been given under the coercion and duress. Here I will also rely on that. It is the division bench of the Calcutta High Court which for the first time came to a conclusion that such no claim certificate had not been submitted under coercion and duress. It was held and found. From the submissions made on behalf of the respective parties and particulars from the submissions made on behalf of the appellant, it is apparent that unless a discharge certificate is given in advance, payment of bills are generally delayed. Although clause 43.2 has been included in the general condition of contract, the same is meant to be a safeguard as against the frivolous claims after the final measurement. Having regard to the decision in Rashmi construction, it cannot be no longer be said that such a clause in contract would be an absolute bar to the contractor raising claims which are genuine even after the submission of such no claim certificate. My lord, from then next page, paragraph 13, from the above conclusion of this code, the following principles emerges. Merely because the contractor has issued no due certificate, if there is an acceptable claim, the court can reject the same on the ground of issuance of no claim certificate, no due certificate. Court cannot reject the same on the ground of issuance no claim certificate. Inasmuch as it is common that unless the discharge certificate is given in advance by the contractor, payment of bills are generally delayed. Hence, such clause of the contract would not be an absolute bar to a contractor raising claims which are genuine at a later date, even after submission of the no claim certificate. Pausing here for a moment, my lord, I can, if your lordship kindly allows me, to place one document at page 59 of this bunch of affidavit. 59.
I have.
This is the railway's letter
to
the contractor claimant. The next page is the typed copy. May I place it before your lordship? In connection with the above, it is to mention here that the final bill along with variation statement, MB material statement, etc. are received by this office from ACPBG on 11/10/2007. During checking of the bill of this bill and variation V statement, it is seen that you have signed in MB bill and variation statement without giving final certificate as required in final bill. You are therefore requested to please attend this office within 7 days after receiving of this letter and mention issue final certificate in the NS bill. Variation statement. Otherwise, the railway will presume that here should be presume that you have no claim outstanding in this work. So it is otherwise a coercion and pressure, undue pressure given on them that unless I sign the no due certificate, then I have no claim, even against the final bill, which was prepared and signed by me. So under duress and pressure, I had to sign the no claim certificate. Therefore, under this judgment, my lord, I am, my lord, entitled to the protection that
what about
so far the first part is concerned that it is my lord, beyond the scope of the contract.
Yes.
My lord, I was directed by the railway authorities to, my lord, execute certain works beyond the scope of the contract. I have stated. And those works, when day-to-day executed, the authority concerned in the site order book put their signature in proof of the fact that the work was day-to-day was being executed. Maybe it is, my lord, beyond the scope of the contract. Maybe.
You should have filed a suit.
My lord?
File a suit.
My lord,
You should have filed a suit at that time.
my lord, if
Why arbitration?
I'm telling you, lordship.
When you are admitting that
My
it
lord,
is beyond the scope.
My lord, scope is this, my lord. When the tender was, my lord, published, or then, my lord, the work was for my lord, the change of RCC concrete sleeper and allied works.
Yes.
At that time, there was at the relevant time there was devastating flood. There was devastating floods.
Yes.
In result whereof, the lines were
Where's
emerged.
the agreement?
Hello?
Where's the agreement, sir?
Agreement.
Is the contract here?
Is not. No, agreement was. Is not.
All right. In your statement of claim?
Yes, I have statement of claim.
Statement of claim, where have you mentioned the contract, that you're part of the contract?
My lord, the statement of claim in the affidavit.
Which para of?
Oh, yes, my lord.
My lord, agreement is there, my lord, at page 43 of their supplementary affidavit.
There, no? Is there a statement of
Only
claim?
only the front page he has given.
Yes.
There should be.
This is the agreement.
Even hai.
43, 44.
My lord, the tender document was part of the agreement. He has not annexed the tender document. He has only annexed these 2 pages.
All right. Where's that letter, madam? The no due
Page
certificate letter.
43 of their supplementary affidavit.
Page 43.
Of their
Then
supplementary.
contract. Contract is page 43.
Contract is page 43.
43, my lord.
Yes. Where is that letter, madam?
Which letter, my
That
lord?
no due certificate.
Oh, that is
Yes, my lord.
in
It is
my
at
opposition, my lord. Page 20 of my opposition.
Nikalna opposition.
My lord, it is not their case that they have given the no claim certificate under duress or coercion. But
Let me see.
my lord, at the bottom,
opposition to the main petition, section 34.
your lordship got it. In the bottom they have.
Opposition. Page কত দেখাচ্ছে?
Page 2.
Page
Can you
20.
show me your copy?
It is marked.
This looks like a yeah, same. All right, it's here.
My lord, I have other claims also within the scope of the agreement. I have other claims. I have, my lord, I have annexed to this supplementary affidavit the statement of claim.
All right.
Where, my lord, I have made averment of the claims, particular claims.
All right, sir, I've seen that.
At page 32 starts.
All right, sir. Anything else?
My lord, one thing kindly consider,
sir,
that I was, my lord, directed by the authority
Yes.
to do the extra work. Now, clause 39 of the general conditions of contract says that any extra work even beyond the scope of the contract,
Yes.
then what will happen? What will be the rates? That is there. Therefore, clause 39 otherwise entitled the contractor to execute work even it is beyond the scope of the contract, and providing certain provisions for regarding payment.
All right.
Then, my lord, if that be done as per their instruction in connection with the contractual work. In connection, your lordship kindly see, this is not a work, that the particular work not within the scope. This is not a work beyond the scope of the contractual work. It is, my lord, within the scope of the, it is, my lord, incidental to the, why it is incidental to the contract work, I say, that at that time, by reason of the devastating flood, the railway track was, my lord, gone down, and it was, my lord, by siltation was there, which required the track to be uplifted by 12 inches. I have stated everything, my lord, by 12 inches.
Anything?
Yes, madam.
Yes.
Madam, he has signed
I've
this
seen that.
no claim on 27th February 2008. Thereafter, on 24th September 2009, he made request to the general manager for appointment of arbitrator. In between 27th February 2008 and 24th September 2009, there is not a single letter. They have given to the railway authorities stating that under duress or coercion, we have issued that no claim certificate. We have some dues or we have done any extra works, as my learned friend is stating now. There is
Anything?
not a single letter.
All right. So from 2000?
My lord, 27th February 2008. They have signed this no
Signed
claim.
this, right?
And they have made request to the general manager for appointment of arbitrator on 24th September 2009.
9. After 2 years. Literally, I mean. All right. Anything else?
This is the main point.
Kindly consider this, that this work,
Third
extra work is incidental to.
Save.
My lord, the general condition of contract is not annexed.
What's the set out?
It is set out in the award.
Nothing in the award.
Yet, for them.
Nothing much, sir, in the award.
My lord, nothing mentioned in the award.
All right.
Nothing mentioned in the order. 7 except as it fell from your lordship that it is outside the scope of the work. But they have, my lord, insisted us to this. Unless we do this, the main original part contract work cannot be executed.
But
Unless it is
not that
uplifted.
Coercion or duress, he has signed the certificate. He has not stated anywhere.
But document is there.